Begin our hearing. I'm now going to count down from 5 so the technicians can begin the public streaming of this hearing. 5, 4, 3, 2, 1. The House Committee on the Judiciary will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on secrecy orders and prosecuting leaks, potential legislative responses to deter prosecutorial abuses of power. Before we begin, I would like to remind members that we've established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members may want to offer as part of our hearing today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. For those in the room, current guidance from the Office of the Attending Physician is that individuals who are fully vaccinated for COVID-19 do not need to wear masks or maintain social distancing. Fully vaccinated individuals may, of course, choose to continue wearing masks based on their specific risk considerations. If you are not fully vaccinated, the Office of Attending Physician requires you to wear a mask and maintain 6 feet of social distance. Finally, I ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. On May 7th, 2021, the Washington Post reported that the Trump administration secretly obtained phone records and had sought email records of certain of its reporters. Later reports showed that the department made similar attempts to access the communications records of a CNN reporter and multiple journalists at the New York Times. On June 10th, it was reported that the Trump administration had also requested the records of multiple members of Congress, their family members, and congressional staff. On June 13th, the New York Times reported that the Trump administration had sought similar records from accounts associated with former White House counsel Don McGahn. Even if that were the end of the story, if all the department had done was target these reporters and these members of Congress this one time, we would have reason to be concerned. A free press is vital to our democratic system, and the Constitution grants extraordinary protections to the official communications of members of Congress and their staff. But of course, these reports do not constitute an isolated incident. The Department of Justice has a long history of targeting reporters and misusing its surveillance authorities to bypass basic constitutional protections. President Nixon's Justice Department tried to silence the publication of the Pentagon Papers. President Bush's Justice Department went after the reporters who helped expose the NSA's expansive warrantless surveillance programs. President Obama's Justice Department went so far as to charge a reporter as a co-conspirator in violation of the Espionage Act. President Trump's Justice Department appears to have targeted reporters and members who were focused on investigating Russia's interference in the 2016 election. And now we know that President Biden's Justice Department sought to renew at least some of the secrecy orders associated with these cases. In each of these cases, the department took advantage of outdated policies that make secrecy the norm, not the exception to the rule. In fact, these recent cases appear to have targeted journalists, Democratic members of the House of Congress, and the former White House counsel. We have no immediate way of knowing how big the problem is because each of these cases was accompanied by a DOJ-requested judge-imposed gag order that prevents anybody from talking about them for years. Now we have asked the department to explain the extent of these troubling cases, but this hearing is not about that investigation, at least not directly. Today, the committee is going to focus on a related policy problem that has troubled members on both sides of the aisle, namely that technology has vastly outpaced the law when it comes to the government demanding your data from a third-party provider, and that the gag orders accompanying those demands have become standard practice in cases where timely notice would make far more sense. In the 21st century, federal prosecutors no longer need to show up to your office. They just need to raid your virtual office. They do not have to subpoena journalists directly. They just need to go to the cloud. And rather than providing Americans with meaningful notice that their private electronic records are being accessed in a criminal investigation, the department hides behind its ability to ask third-party providers directly. They deny American citizens, companies, and institutions their basic day in court, and instead, they gather their evidence entirely in secret. Just because it is easier for prosecutors to seek sweeping amounts of data from these service providers does not mean that they should be allowed to do so. This committee has long recognized the Justice Department's need to investigate the unauthorized disclosure of classified information, and it supports those investigations whenever they are properly predicated. Our responsibility to combat leaks is not, however, carte blanche authority to engage in sweeping surveillance of American citizens, businesses, newsrooms, and universities. It was not tolerable after 9/11, and it is not acceptable now. If history and recent reporting has taught us anything, it is that we cannot trust the department to police itself. It is imperative that the committee fulfill its role and ensure our laws are keeping pace with rapidly changing technology. We need to guard against future overreach of federal prosecutors by implementing reform now. I thank our witnesses for being here today. I look forward to hearing their ideas on what reforms we should consider moving forward. And I look forward to working with Mr. Jordan and our Republican colleagues on this matter. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, in the United States of America, the government should not spy on its citizens, plain and simple. In the limited cases when surveillance on Americans is necessary to prosecute crimes or prevent acts of terror, there should be a high burden, a very high burden for the government in getting approval to do so. What came out of the Church Committee's investigation into the FBI's rogue actions in the middle of the 20th century provided a roadmap for righting the wrongs of domestic surveillance. An entire apparatus of checks and balances was set up to hold government accountable when it sought to invade the privacy of its citizens. But this process, again, is now in need of reform. The laws and guidelines governing surveillance are opaque, antiquated, and easily skirted. Our system of warrants, subpoenas, national security letters, secret courts, and other tools at the government's disposal must be brought in line with constitutional considerations of basic due process. We've tried to make progress in recent years, but we have much work left to do. For instance, the USA Freedom Act made significant improvements to the Patriot Act to safeguard civil liberties, but many deficiencies remain, like the simple fact that the Obama FBI spied on President Trump's campaign, used a dossier that they knew to be false at the time to be able to surveil the activities of Carter Page. Further improvements, or quite frankly, a complete overhaul of FISA is something this committee should again take up. More recently, Tucker Carlson stated on his show the other night his belief that the NSA was monitoring his communications. While the NSA said in a carefully worded statement, and I would encourage all of you to read that Mr. Carlson was not the target, not a target, they didn't deny that they had reviewed his communications. Additionally, reforms to the Electronic Communications Privacy Act, or ECPA, passed the House in 2 recent Congresses, only to stall in the United States Senate. As most of our colleagues know, ECPA is the cornerstone law governing Americans' privacy with respect to email and other electronic data. The problem is that this law was written in 1986 and did not contemplate, not even close to contemplate, all the facets of our digital age today. The result has been a patchwork system of demands from law enforcement to technology companies in a constitutionally dubious fashion. Courts are split, for instance, on how to interpret parts of ECPA, and this uncertainty allows for data to be swept up by law enforcement agencies without warrants. Another area where we can work together is on protecting the public's right to know. An informed public is critical to a well-functioning democracy. When the Department of Justice prosecutes journalists or implements a gag order so that people cannot speak out about the government's actions, our democratic values are undermined. There are bipartisan bills that would protect journalist sources. This legislation was originally authored by Vice President Pence when he was a member of the House. We should revisit this legislation, and also measures related to gag orders so that the public can be as informed as possible. It should be incredibly rare in the United States that people are not allowed to speak freely about the government's actions. I look forward to today's discussion, and frankly, like the chairman said, I'm optimistic about an opportunity to work with our colleagues on the other side to make some improvement in all these areas. With that, Mr. Chairman, I yield back.
Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Eve Burton is an Executive Vice President and the Chief Legal Officer of the Hearst Corporation. Prior to joining Hearst, Ms. Burton served as Vice President and Chief Legal Counsel at CNN, where she oversaw all legal matters relating to news and other programming on CNN networks and websites. Previously, she was a Deputy General Counsel at the New York Daily News. She also clerked for Judge Leonard Sand in the United States District Court of New York. Ms. Burton holds a BA from Hampshire College and a JD from Columbia Law School. Tom Burt is Corporate Vice President for Customer Security and Trust at Microsoft Corporation. Among his department's many responsibilities is responding to law enforcement requests for access to data and managing Microsoft's government clearance and national security compliance. Mr. Burt joined Microsoft in 1995 and has held several leadership roles in the corporate, external, and legal affairs departments. He received an AB from Stanford University and a JD from the University of Washington School of Law. Jonathan Turley is the J.B. and Maurice C. Shapiro Professor of Public Interest Law at the George Washington University Law School. After a previous position teaching at Tulane Law School, Professor Turley joined the GW Law faculty in 1990, and in 1998 he became the youngest chaired professor in the school's history. In addition to serving as counsel in a number of significant cases, he has written numerous articles for a variety of law journals and national publications. Professor Turley earned a BA from the University of Chicago and a JD from Northwestern University School of Law. Lynn Oberlander is of counsel with the law firm of Ballard Spahr, LLP. Previously, she served as Previously, she served as in-house counsel to numerous broadcasters, publishers, and digital platforms. She was a senior vice president and associate general counsel for media at Univision Communications, Inc., while also serving as executive vice president and general counsel at Univision's subsidiary, Gizmodo Media Group. Previously, she was the general counsel for media operations at First Look Media Works, and before that, she was the general counsel of The New Yorker, where she also wrote for NewYorker.com on media law topics. Earlier in her career, she also worked at Forbes and NBC. Ms. Oberlander received her BA from Yale University and her JD from Columbia Law School. We welcome all of our distinguished witnesses, and we thank them for participating today. I'll begin by swearing in our witnesses. I ask that our witnesses in person please rise and raise your right hand. I ask that our remote witness please turn on her audio. Make sure I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God?
I do.
Let the record show that the witnesses have answered in the affirmative. Thank you, and please be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time limit, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witness appearing virtually, there is a timer on your screen to help you keep track of time. Mr. Burton, you may begin.
Thank you. Chairman Nadler, Ranking Member Jordan, members of the committee, good morning. My name is Eve Burton. I'm an Executive Vice President and the Chief Legal Officer of the Hearst Corporation. I am pleased to appear before you today to discuss this critical issue. This is not a partisan political matter, and it is not a concern limited to the press or the Congress. It is an American issue, and how we approach it will tell a lot about what kind of country we want to be. I want to acknowledge the obvious. There is a natural tension between prosecutors' interest in exercising their investigative power and the individual's interest in protecting their constitutional rights. And these are difficult interests to balance. But that is the key. They must be balanced fairly and consistently. Our constitutional system requires that due process is accorded all citizens through the application of proper procedures that protect fundamental rights. With rare exceptions, these matters should not be decided in secret. Recent revelations about the DOJ's use of its investigative powers to secretly obtain citizens' communications record directly from telephone and email providers should be of great concern to every American. We all rely on these services in our daily lives. While we do not yet know all the details of how or why the DOJ went about this secret collection, enough facts have emerged to suggest that Congress should consider legislation to ensure appropriate balancing and adequate protection of individual rights in the future. Congress has stepped in before to provide legislative protections for important rights, as it did with the 1980 Privacy Protection Act. The PPA established strong procedures for news organizations to challenge search warrants of newsrooms, which were, until then, planned and executed in secret. Congress should do more, especially where third-party communication companies are concerned. That is the principal unaddressed problem in 2021. The aim of my testimony is to share my views on what should be central components of any legislative reform in this area. My written submission provides an expanded discussion of these necessary pieces, but I will summarize them here. The single most important step, and one that is steeped in our shared American values, is to recognize the importance of due process and procedural safeguards. This could be done by codifying something like the DOJ subpoena guidelines. They lay out procedures to protect fundamental press rights from investigative power. This is a good baseline for legislation to address today's problems. But the guidelines are just a starting point, and we must go forward. Further, to that end, a critical second step is to recognize the necessary role of Article 3 judges in balancing competing interests. The DOJ should not be prosecutor, judge, and jury when it comes to citizens' fundamental rights. The department simply has an inherent conflict. A third step is the establishment of procedures that specifically recognize the realities of modern communication technology. The same protections must apply whether the information is sought in an office file or on a cloud server across the country or the world managed by Google, Microsoft, Apple, or Verizon. These are not theoretical issues, they are practical issues. We must extend procedural protections to records stored with cloud companies, or else we may never know when our records are seized by the government. Presently, the protection of our constitutional interests are in the hands of middlemen who have no incentive to battle with the government on behalf of customers or citizens. To the contrary, in my experience, some communication companies have historically seen it as their responsibility to assist the government in obtaining what it wants. Finally, legislation should be clear. There is a presumption against secrecy orders, and the government must bear the burden of overcoming that presumption. The Pentagon Papers case, decided exactly 50 years ago today, reminds us that prior restraints are rarely, if ever, constitutionally permissible, even when the government invokes national security concerns during wartime. This is the constitutional presumption against which gag orders must be judged. I would like to close my testimony by reiterating my belief that much of our concern about prosecutorial abuse of investigative power can be addressed in a way that should not be controversial or interfere with legitimate government work. Instead, I believe we can all agree that many of these concerns can be addressed with clear procedures that establish a presumption of openness with notice and an opportunity to be heard as the norm and the expectation. This ensures that difficult questions about the balancing of constitutional interests that must occur will be properly decided by our great and independent judiciary. I look forward to our discussion today and thank you all for the opportunity to participate in this hearing.
Thank you for your testimony, Mr. Burt. You may begin.
Chairman Nadler, Ranking Member Jordan, and members of the committee. My team at Microsoft is responsible for responding to government data demands, so I appreciate the opportunity to testify on the need for legislative reform on secrecy orders. While the recent news about secret investigations is shocking, most shocking is just how routine secrecy orders have become when law enforcement targets an American's email, text messages, or other sensitive data stored in the cloud. This abuse is not new. It is also not unique to one administration and is not limited to investigations targeting the media and Congress. Secrecy orders are too often used for routine investigations based on a cursory assertion that the government has met a statutory burden. The Justice Department's own template does not even require facts justifying the need for secrecy. Instead, the template merely asserts that any disclosure would seriously jeopardize the investigation for a variety of boilerplate reasons. It's no surprise then that throughout the Obama, Trump, and Biden administrations, up to a third of all legal demands we receive from federal law enforcement include secrecy orders, up to 3,500 in just 1 year. And these are just the demands on Microsoft. Add the demands likely served on Facebook, Apple, Google, Twitter, and others, and you get a frightening sense of the mountain of secrecy orders used by federal law enforcement in recent years. As has been pointed out, this is very different than investigations conducted before the advent of cloud computing. If law enforcement wanted to get access to data on a computer or a network in your home or your office, they would have to obtain and serve a warrant in order to enter your premise and collect evidence. If law enforcement wanted to secretly search your physical office, it had to meet the heightened standards required to get a so-called sneak and peek warrant. However, today, if law enforcement wants to secretly search your virtual office in the cloud, they just serve a boilerplate warrant and secrecy order on your cloud provider that prevents notice to you. Microsoft scrutinizes each legal demand we receive to protect our customers' interests. We often challenge unnecessary secrecy orders through negotiation or litigation in court. But some examples, just examples of some of the recent abuse we've seen are secrecy orders when the account holder was a victim, not a target of the investigation. Or when the investigation targets just one account at a reputable company, government, or university, but the secrecy order bars notice to anyone in that organization. Or where the government has secretly demanded records in order to evade an ongoing discovery dispute. While Microsoft has long successfully challenged these secrecy orders in courts, litigation is no substitute for legislative reform. We worked with other technology companies and have reforms that we've proposed that permit secrecy orders for those rare cases where they are truly necessary. We have 4 primary recommendations. First, Congress should end indefinite secrecy orders for good. We suggest that they last for 90 days with a 90-day extension if proven necessary. Second, Congress must end rubber-stamped secrecy orders and require that judges engage in a written analysis of the relevant facts. Third, courts should apply strict scrutiny when issuing an order, instead of only after it has been challenged. Finally, Congress should codify a statutory right authorizing cloud providers to challenge harmful secrecy orders in order to protect their users' rights. Let me be clear, secrecy orders are sometimes necessary, such as to investigate cyber attacks, to keep our children safe from online exploitation, or to prevent terrorist attacks. We don't suggest that the government must meet an impossible standard. We are asking for a meaningful one. Notice to targets is an important safeguard for our constitutional rights. Reform is necessary to protect the fundamental values that are the bedrock of our democracy. Without reform, abuses will continue to occur, and they will occur in the dark. Thank you for your time and attention.
Thank you for your testimony. Professor Turley, you may begin.
Thank you, Mr. Chairman, Ranking Member Jordan, members of the Judiciary Committee. Thank you for inviting me to speak today. The reporting targeting of reporters and members of Congress in the recent leak investigation is a serious matter that cuts across areas of constitutional and statutory law. It should also cut across partisan lines to unify the public and the Congress in seeking answers to these difficult and troubling questions. Today's hearing occurs on the 50th anniversary of the New York Times' publication of the Pentagon Papers, an act that triggered one of the most consequential legal battles in the history of this country, a battle that ultimately helped define the rights of the free press. It also reminds us that drawing the line between national security and press freedom continues to evade clear demarcation. Indeed, it was 15 years ago that I testified before the House Intelligence Committee and called again for the enactment of a federal shield law. It's a reminder of how this area remains dangerously ill-defined and uncertain for reporters, particularly with the growth of new technology that has made a mockery of many of our protections. This is a difficult area because there's compelling arguments on both sides by the Department of Justice and by the media. And courts have struggled with what is often presented as a zero-sum game. And you can see that in the cases that I discuss in my testimony. So this is a very serious matter. We don't know all of the facts, but it cuts across and raises issues of separation of powers, the free press, and privacy. I'd like to, however, focus on where I ended 15 years ago, and that is on the necessity of a federal shield law. But I will note that my testimony identifies 6 areas that I believe should be explored in light of this controversy. Frankly, for those of us who have advocated for the free press and for free speech, this is what Yogi Berra meant when it was all deja vu all over again. We have seen this in the Bush administration, we've seen it in the Obama administration, we've seen it in the Trump administration, we saw it at the beginning of the Biden administration. It's foolish to believe that anything is going to change. In fact, that, I believe, is the definition of insanity, of doing the same thing expecting a different result. The fact is, we rely uncomfortably on self-regulation by the Department of Justice. They have not met that burden. They have failed over and over again. It is not partisan. It cuts across parties and administrations. It is a record of failure that puts at risk one of the most precious rights, one of the most essential rights in our constitutional system, and that is the free press. The 6 areas I laid out include concerns over the authorization in this matter, what I call reverse engineering of leak investigations, gag orders, phishing in the cloud, which is a major problem, national security letters, and defining journalism. But I really would like this committee to begin and end, and this will come as no surprise to the chairman and the ranking member, that I invoke James Madison. As a Madisonian scholar, I think most things begin and end with James Madison. And Madison said most famously, a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and people who mean to be their own governors must arm themselves with the power that knowledge gives. It's the free press that gives us that knowledge. It's the free press that protects us most certainly from tyranny. I won't address the case law that I have discussed, but I will note this. The state legislatures have been far more protective of the free press than this body. There are 16 states in the District of Columbia that have absolute privileges for the media. There are 24 states that have qualified privileges for the media. Other states that don't have those shield laws actually have common law protections for the media. The Free Flow of Information Act of 2017 is a great platform. It is supported by both parties, and it is time that we move that to enactment. I am critical of aspects of the law, even though I would take that law right now in a heartbeat to try to gain that protection for the media. But I note that it could be strengthened with a greater explanation of presumptions, but also I believe it has to be rewritten on the definition of what constitutes a journalist. Journalism has changed in this world, and the definition in the law is frozen in journalistic amber that is ages out of date. And so I would suggest examining that. I will only end with this, as I did 15 years ago. We cannot afford the consequences of leaving the media exposed the way we have. That will leave not just them exposed, but the public in the dark. It will be, as Madison said, a prologue to a farce or a tragedy or both. We can avoid both, and we need to pass this law. Thank you.
Thank you for your testimony. Mr. Oberlander, you may begin.
Chairman Nadler, Ranking Member Jordan, and members of the committee, thank you for inviting me to testify today. We have learned in the last few weeks that the Justice Department has secretly sought the email and telephone records of 8 journalists who work for 3 media companies in what appears to be a purposeful attempt to evade the protections of the law and of the department's own guidelines. As a longtime media lawyer who has worked in many newsrooms and with hundreds of journalists, I can report that these actions have had and will continue to have a profound and disruptive effect on the ability of journalists to practice their craft and to report stories of vital public importance to our democracy. By sending secret subpoenas to the service providers for the New York Times, the Washington Post, and CNN, and then by gagging the recipients, the Department of Justice performed an end run around the protections for the news media provided in both the Privacy Protection Act of 1980 and the Attorney General's own news media guidelines. Had the subpoenas come directly to the media organizations, or if they had been notified at the time of their issuance, the media organizations would have been able to challenge them in court. Instead, and even though the prosecutors were seeking 3-year-old records for an already public leak investigation, the Department of Justice was able to convince a magistrate judge in at least one of the cases that informing the journalists of the request would, quote, seriously jeopardize the ongoing investigation by giving targets the opportunity to destroy or tamper with evidence. Congress should now act to more fully protect the rights of journalists to bring crucial information to the public. The honorable members of the Judiciary Committee should consider several legislative enhancements. The strongest and simplest way to protect the rights of journalists to report on the actions of government and the rights of the public to receive such reporting would be to pass legislation banning governmental inquiries into journalist sources, as Attorney General Garland has now said that he would strive to do. This would be the simplest response and would demonstrate the importance of the free flow of information to the public. But even in the absence of such a ban, there are other ways to improve protections for journalistic process. Independent judicial review of any prosecutorial attempt to access journalist materials is crucial, and ensuring that it's a stringent review that appropriately weighs the public's interest in news gathering with the government's interest in uncovering a source is central to protecting the important First Amendment interests that are at stake here. While the current Attorney General guidelines are not perfect, and crucially are not enforceable by journalists, they provide an excellent starting point in looking to strengthen the legislative protections. The guidelines recognize that, quote, freedom of the press can be no broader than the freedom of members of the news media to investigate and report the news, and note that subpoenas and search warrants are extraordinary measures, not standard investigatory practices. To this end, all such process may be issued only with the approval of the Attorney General or another senior official, and only when the information sought is essential to a successful investigation, after all reasonable attempts have been made to obtain the information from alternative sources, and after negotiation and notice with the affected members of the news media. These protections should now be statutorily enacted. The government must provide notice to the news media whenever information is sought, whether it's directly sought from the media itself or from their service providers. It is an accident of technology that the government is able to bypass the affected journalists. If the media company maintained its own email servers, for example, it would be impossible to seek the records without notice. Notice provides an opportunity for the affected media to seek judicial review from an Article III judge and to challenge the government's purported rationales for seeking the information. The Department of Justice believes that prior notice and negotiation is impossible in certain cases, particularly where it threatens grave harm to national security or the investigation's integrity. In such extremely limited cases, Congress should consider legislating a duty of candor, an affirmative obligation to notify the third-party providers that it is seeking journalist materials and not to hide the request within a broader request, as was apparently the case with the subpoena to Apple for information about members of Congress and their staffs. Congress should also consider requiring a confidential advocate to represent the media's interest before the court considering the application for the subpoena, the court order, or other process. This would not be unique. The USA Freedom Act permits a similar type of special advocate in proceedings before the FISA court. And finally, this moment presents an excellent opportunity to pass a strong statutory shield law that would codify protections for journalists and mandate a consistent test for when, if ever, the government or private individuals can seek journalist work product and the identity of confidential sources. Today's patchwork of shield laws and conflicting standards of protection between the state and federal courts leads to inconsistent results and prevents journalists from adequately informing their sources of the risks they face in coming forward with crucial information for stories of public importance. Truly a fourth estate to our tripartite government, the press, protected by the First Amendment, stands as an essential bulwark of our constitutional arrangement. Congress can help the press serve its vital role in our democracy. I urge you to do so. Thank you.
Thank you. We will now proceed under the 5-minute rule with questions, and I will recognize myself for 5 minutes. Before I begin my question, and without objection, I will place the following into the record. A letter from over 20 civil society groups calling for reform, a statement from Frederick J. Ryan, Jr., CEO and publisher of the Washington Post, a statement from Karen Kaiser, Senior Vice President, General Counsel, and Corporate Secretary of the Associated Press. Without objection. The technological landscape has changed dramatically since Congress enacted the Stored Communications Act in 1986. Mr. Burt, how has the government become more and more reliant on Section 2703 electronic surveillance orders since the passage of the Stored Communications Act in 1986?
Government has become increasingly reliant on these secrecy orders since that time, and that has been largely the product of the advancement of technology. At that time, the cloud didn't exist, and the substantial extent to which citizens, organizations, corporations, and society in general stores their private communications, their corporate records in the cloud, that didn't exist. And so today, what we have is a world where access to that information and the application of a secrecy order enables law enforcement to conduct these investigations and get access to citizens, organizations, corporation records without notice to the organization or the individual whose records are being obtained. And that is a dramatic shift in the way law enforcement can and should conduct its operations.
Ms. Burton, what are some examples of cases in which you think the government would not need to rely on Section 2703 orders, but it in fact does?
I would point the committee to the Balco case, which was a series of stories by the San Francisco Chronicle on sports and steroids, where the government had a two-party process to get information. They were going through the courts and they didn't like the results they were getting. So they turned around and they went back through the service providers and they sought the telephone records of the reporters in court without any notice to us. That order is still sealed. We have no knowledge whatsoever what the telephone provider argued in the courtroom. A perfect example of a relatively routine case. The government was embarrassed about what happened in the grand jury and what came out of the grand jury. And it just wasn't necessary. The usual constitutional protections and the courts balancing those and with notice to these reporters was a perfectly fine way to proceed. Whether they won or lost the case, it was fair under a constitutional scheme. So there's an example where it was just easier for the government to get what it wanted, and it got it, and it acted in accordance with process that's just not defensible in this country under our aversion to secrecy, as Representative Jordan spoke about when he started with you in this proceeding.
Mr. Burt, same question.
In addition to the examples that I described in my testimony, let me just offer a very recent example. We received just yesterday a demand for access to data of a single employee of a major American city in an investigation that has nothing to do with national security. And the gag order therefore prevents us from notifying anybody in the city, not its mayor, not its city attorney, that an employee of theirs has had their information taken by the government. And more importantly, we also saw with this particular gag order a new trend, or an example of a new trend, troubling trend that we're observing, which was this gag order wasn't just about that subpoena. It was a blanket gag order that purports to cover all subpoenas, all warrants, process in that entire investigation, in that entire case, all based on one boilerplate submission to a magistrate. And that's the kind of, our law enforcement agents work hard to do a very important job, but the law as it currently exists enables them to act this way out of expediency and convenience. And that's why we need reform.
Thank you. If the recent reporting is true, gag orders prevented counsel within these targeted media companies from sharing any information about the request for information with the affected reporters. This dynamic strains the attorney-client relationship, to say nothing of its effect on a free press. Ms. Oberlander, does the department's use of secrecy orders violate due process protections? And why do you believe the department defaults to Section 2703 and secrecy orders in this way?
I absolutely believe that it does violate due process. It creates incredible stress for the media organizations and for the lawyers at issue here. The in-house counsel who were aware of the request, but who weren't allowed to tell their bosses, their supervisors, or the journalists, or even the newsroom, that these requests had been made. It puts them in an incredibly difficult position, as I'm sure, as many of you are members of the bar, you can imagine, when you cannot tell your client crucial information about what is being asked of them and going on. The other big problem is that when you have these secret orders, you can't negotiate them. I mean, if the order had come through and the people were allowed to know about it, then they could go back and say, you don't really, even if you want this information, which we don't think you should have, you don't want this other information. We want to make sure that you're not getting other communications that may show our other sources, our other work product, or other confidential investigations. And so it really makes it very, very difficult for in-house counsel and outside counsel to work effectively with the government and to protect their First Amendment rights.
Thank you. My time has expired, Mr. Jordan. Mr. Gates.
We're on a roll, Mr. Chairman. Last week, you brought big tech to heel. This week, bringing the Department of Justice to heel. My heart flutters to think what might be in our next committee week. Maybe we'll reform FISA and continue the bipartisan momentum. I believe that the Department of Justice and the intelligence community shouldn't threaten or spy on members of Congress, our staff, or the press for politics. President Biden believes the same thing. In response to questions from CNN's Caitlin Collins, President Biden committed that he would not allow the weaponization of his government against the press. Chairman Nadler agrees. Matter of fact, Chairman Nadler stated, and I'm quoting directly, Congress must make it extraordinarily difficult, if not impossible, for the department to spy on the Congress or the news media. We cannot rely on the department alone to make these changes. When I saw the reports about members of Congress offices being targeted, Mr. Swalwell, Mr. Schiff, I was the first and the only Republican to say that that was improper. And more of my colleagues should join me. It was easy to believe that the Department of Justice would do that to the Democrats because they threatened to do it to us. Mr. Chairman, I seek unanimous consent to enter into the record Fox News publication from September 27, 2018, Rosenstein launched hostile attack in May against Republicans over Russia records.
Without objection.
Rosenstein threatened Kash Patel, who was a member of Republican staff, with criminal process if he did not bend to what Mr. Rosenstein wanted at the time. So it's not hard to believe. The most watched cable news host has been stating for the last several nights that the NSA has been monitoring his communications. And amazingly, the NSA has issued a statement that is so couched, it is functionally an admission. Let's review. The NSA says, on June 28, 2021, Tucker Carlson alleged that the National Security Agency has been, quote, monitoring our electronic communications and is planning to leak them in an attempt to take this show off the air, close quote. This allegation is untrue. But which allegation? The statement continues. Tucker Carlson has never been an intelligence target of the agency, and the NSA has never had any plans to try to take his program off the air. And the statement continues. But what's interesting is that there is no denial that they were monitoring Tucker Carlson, even if he wasn't the target. We saw this exact playbook with Carter Page and Donald Trump, where in order to try to assess information from one person, the intelligence community will utilize authorities to go after someone else to try to ensnare their true target. I think that's why they were going after Democrat staff, to try to get to Schiff and Swalwell. I think it's the reason they were going after Republican staff, perhaps to target Mr. Nunes or others. I think it's why they were going after Carter Page to get to Trump. And I think that there was probably somebody in Tucker Carlson's orbit that NSA was monitoring, and there's no denial that they caught up Tucker Carlson in that monitoring. And by the way, there's also no denial that there was a plan to leak the information to try to, in some way, embarrass Tucker Carlson. The only denial is that they weren't expressly trying to get his show off the air. And it's not like the NSA's never lied to us. I mean, we were told that there was no bulk collection of Americans' data. Turns out there was bulk collection of Americans' data. And no one ever was held to account for that. The chairman's right, and Professor Turley's right too. We cannot count on these people to police themselves. And so it's my expectation that there needs to be greater review here. And so, Mr. Chairman, I am inviting you to continue this bipartisanship. Join me in calling for an Inspector General investigation into any monitoring that the NSA or any other element of the intelligence community has engaged in relative to Tucker Carlson. Because these denials, these couch denials, raise more questions than they provide answers. And by the way, if Democrats don't do this, if you're only outraged when your members and your staff and the press that's close to you and that amplifies your messages is targeted, then we never are going to solve anything. It will, in fact, be deja vu all over again, as Professor Turley said. I'm equally outraged when they target the people I like and the people I don't like, when they target the press that I watch and the press that I despise. And I would greatly seek any bipartisan agreement. Last week, we were on such a roll. We brought big tech to account. And my hope is that we can join together again and address this legislatively, but specifically with a call for an Inspector General investigation into these allegations. I yield back.
Gentleman yields back. Ms. Lofgren.
Thank you, Mr. Chairman. As I listen to these very skilled and knowledgeable witnesses, it occurs to me we're being asked to provide additional protection to the press because of the First Amendment. But it seems to me our real focus, not that the press doesn't need additional protection under SHIELD laws, ought to be on the Fourth Amendment. And I think once again, we are called to ask whether the Fourth Amendment is really still alive in the digital age. The warrant requirements and the guarantees against unreasonable search and seizures really they're foundational rights, and they're not just to the press and they're not just to members of Congress, they're to every American. And I do believe that the situation we have here is an end run on the protections that the Fourth Amendment is supposed to provide to every American. It's true that if the information sought was on a person's desktop, a warrant would have to be issued. There wouldn't be a gag order, there'd be notice. And the fact that the information is stored in the cloud instead is really meaningless. The expectation of privacy on the part of the individual is that it's their data. And I think we really need to revisit the whole scheme that we have here about Americans' expectation of privacy. When these laws were written, there was no cloud. And we ought to extend the Fourth Amendment protections to individuals' data wherever held when there is an expectation of privacy. Now, Mr. Burt, I'd like to ask you about compelling cloud providers like Microsoft to produce communication records. The Stored Communication Act allows the government to compel such data upon a showing of reasonable suspicion. Do you think that this standard is sufficient
to protect the privacy rights of individuals who have their data stored in your cloud?
No, that standard is clearly not sufficient, and that's why we're recommending the heightened standard that we do recommend that the committee consider in legislative reform. That standard has then turned into these boilerplate approaches that we discussed that enable law enforcement to just simply assert a conclusion that the secrecy order is necessary. And then, as you point out, quite accurately, that denies the target of that investigation any opportunity to exercise their Fourth Amendment rights because they don't know that their property is being taken and searched and seized. What we've done in our litigation is assert our First Amendment right to inform our customers. And that, while some courts have recognized that we do have a First Amendment right to inform customers, and that's why we also believe part of the reform should clarify that that First Amendment right does exist for cloud providers, because there have been some courts that have found the opposite. We really need to ensure that citizens have the opportunity to exercise their Fourth Amendment rights, and that requires a heightened standard. It requires the specific findings of fact that a secrecy order is truly necessary under the existing statutory factors, and a record so that only in those very limited instances where it's truly necessary in the national interest is a secrecy order applied, and not 3,500 times a year just to one cloud provider.
Right now, I mean, the entire burden of protecting Fourth Amendment rights falls upon the service provider. Now, I heard your testimony that Microsoft is active in protecting those rights, but there are other providers that may not be active. The fact is, it's the individual whose rights are being challenged who should have the opportunity to contend and to protect. I'd like to think, what happens when a court issues a secrecy order that later turns out to be totally unsupported, and yet the government uses the information it gets in the request to bring a criminal prosecution? Can the defendant use the secrecy order as a basis for suppression? Do you know that?
I would yield to witness Mr. Turley to see if he's got a specific analysis of that. But I believe the answer is there is no opportunity for the defendant then to challenge that the evidence that's seized in that way under a secrecy order under the Fourth Amendment.
The time of the gentlelady has expired. Mr. Biggs.
Thank you, Mr. Chairman. Thanks to you for holding this very important hearing, and thanks to the witnesses for being here today. And I associate myself with basically everything that's been said here today. It's been remarkably agreeable, which is really pleasant and surprising. So I hope that we can work together to try to bring clarity and rectification of these problems. So here's my first question goes to Ms. Burton. This is for you. You said in your written report, because information's in a cloud storage bin rather than a file cabinet, and this is, by the way, this was iterated by every witness, the government should have no greater investigative and secrecy interest due to the case of due to the ease of access. So I guess my question is, if you were the DOJ or government, how would you respond to that? Because, I mean, that's the blanket statement, is that there is no greater, just because it's easier to claim secrecy, there's no greater cost. How would you respond if you were DOJ to that?
I mean, if I were the Attorney General, and I think he's headed in this direction, I would want to be responsible as a citizen of the country to balance all rights and all needs. And that's why we have judges. That's why we have notice. That's why we should not be putting our cloud providers effectively above the Constitution. As you say, Microsoft makes some efforts in this regard, but that is not universally the issue. And I would tell you there's a lot of things we don't know right now. And if I'm the DOJ, I don't want to be convicting people or bringing cases where I can't defend in full measure the evidence that I put before a court and give someone the right to challenge that. I think that's just, playing, should we say, pro ball in a bad way.
Well, I don't disagree, but I haven't heard basically from any of the witnesses, nor have we seen in practice over years that DOJ really is concerned with being a pristinely good due process adherent and protecting the rights of everybody. I mean, you've all iterated examples where they've abused this authority, and Mr. Burt, this is coming in to your shop 3,500 times a year, and so we're led to believe that this could be many thousands of times. So you've given your set of prescriptions as well, but why do you think it should be? I mean, in a physical warrant, when physical material is being seized, it's 30-day. If it's going to be secret, it's 30-day per statute. Why do you think it should be 90-day for data?
That's a very good question, and any reasonable time is acceptable to us, and I think to the technology industry. What we're trying to do is rein in what we have seen, which are indefinite secrecy orders that have no termination date. What we've seen since the DOJ formulated its policy in response to litigation that we filed back in 2017, we've actually seen somewhat of a decrease in those indefinite orders, but we still get hundreds of those every year. The standard that we see typically is a year, and that's just far too long a time period, even when it's actually justified to have a secrecy order. So our response would be, there's a very small universe of truly justified secrecy orders. Where those secrecy orders are truly justified, then as long as 90 days might actually be acceptable.
So I just have about a minute left, and I would like each of you to respond to this, because each of you have talked about, one way or another, reliance on the courts as arbiters here, and yet they seem to be just rubber stamping boilerplate language. I am concerned about what I view as a necessary stick approach to DOJ for their abuse. What is an appropriate punitive measure? I mean, if in a regular criminal case with physical evidence, you're going to have the exclusionary issues that will come in if there's fruit of the poisonous tree, et cetera. What happens here? What is the punitive measure that devolves to bad actors? DOJ, Professor Turley, will go with you, and then right down the table, and then.
Well, I certainly agree with your point that the courts have not exactly covered themselves in glory, and part of the problem here is that these judges are getting thousands of these things, and they don't want to go into the weeds on some of these issues. And so you have cases like In re Grand Jury out of the ED New York that are saying, look, this is just boilerplate. We're just getting boilerplate over and over again, and that's not saying anything. You're going to have to structure what a court has to find and what a court must establish in writing if we're going to be able to do anything. And I think you have to establish standing and an appellate procedure with adversarial process. Those are the things that will result in a change.
Gentleman's time has expired. Ms. Jackson-Lee.
Okay.
Mr. Chairman, thank you so very much. And I view this as enormously crucial in holding this bipartisan hearing. And it gives me reflections down memory lane of the Patriot Act and the urgency after 9/11 to deal with both, as we fought for in the Judiciary Committee, the balance of civil liberties, as well as this major effort to be able to protect America. We come full circle, I believe, and we are here to protect America again, and we're doing it from a different perspective. Allow me just to lay a predicate, if I might, that under the Trump administration, its Justice Department, they sought the phone and email records of journalists, members of Congress, their families, and their staff. I think this should just we should dwell for a moment. Staff and families. Now, I imagine there's an array of family members, and there might be a toddler. Some said there was a child whose various resources were as well sought. So Donald Trump's determination to repeat the abuses of President Nixon was carried out in his contempt for the invaluable service to democracy performed by a free and independent press, and his desire to punish politicians who oppose or criticize his policies and actions. As I pointed out during the impeachment proceedings against Donald Trump, his conduct reflects and reveals a person whose character is thus marked by every act which may define a tyrant and shows he is unfit to be the ruler of a free people. I say that for the record, not to suggest that what we're doing today should appeal to all of us and apply to all of us regardless of our political perspective, as I heard witnesses say. In fact, Ms. Oberlander, you indicated if sunshine is the best disinfectant, it is obvious that this shadowy state of affairs allows for all manner of dark things to grow. We worked very hard in the Patriot Act to pull back, dealt with Pfizer. Even in our effort to do so, we have had our ups and downs. So let me ask all of you a question. It's just a yes or no to all of the witnesses, and then with the time remaining, I'll ask a specific question. But let me start, Professor Turley. Do you believe that Congress definitively needs to act in the midst of what we're dealing with at this time?
Yes.
Mr. Burt?
Yes, I do.
Ms. Oberlander?
Yes, I do.
And I believe Ms. Burton?
Yes, ma'am.
Thank you. So let me pose this question to Ms. Burton. How might the use of electronic surveillance, gag orders, used to further a president's personal crusade, what impact do you think that has as it relates to the industry?
I would say, Representative, that what you need to do in our answer to yes, and how it would affect not just the industry of the media, because I think what we've really determined here is that this affects all Americans. So I would urge you to put forth legislation that would have a foundational matrix that could apply to the First Amendment, the Fourth Amendment, a narrow statute that covers broad constitutional considerations. And that would be to give notice, due process standards, courts, judges, and no secrecy. I think that combination of things and a narrowly stated, not all of the other issues that we've touched about on a lot of issues, but something very simple and clear that would effectively help our industry and the American public to no end.
Thank you, Ms. Oberlander. Let me ask you the question from the reverse. What should be the limitations on our effort to protect the American public against these random securing of data now in the light of the cloud? Should there be, from your perspective, as a First Amendment specialist, what limitations should we consider, if any?
Congresswoman, I think that, frankly, the protection for the media should be broad, and it should be subject to strict judicial review anytime you're trying to the government is trying to get this material to invade the privacy of the journalist, to invade the privacy of the reporting process. But it may be that there are specific places where you could override that, perhaps on acts of terrorism, obviously, if there is a reason to believe that there's communications around terrorism or the identity of a terrorist. That might be one of the places where you would have a narrow exception. But I do think it is, or imminent bodily harm or violence or immediate death. But in general, I think the protection should be very, very broad and subject to independent judicial review. And as the other witnesses have said, that there should also be the right of interlocutory appeal for that.
And we should
The time of the
cautiously.
time of the gentlelady has expired.
Thank you. I yield back.
Mr. McClintock.
Thank you, Mr. Chairman. I find myself in complete agreement with Ms. Lofgren. This is not a matter of special protections for journalists or public officials. This is a matter of the Fourth Amendment right of every American citizen. It was John Adams, who was certainly in a position to know, who said that, in his opinion, the American Revolution started many, many years before 1776 with the King's abuse of general warrants. That's when he said the child liberty was born. We wrote our Fourth Amendment to assure that such abuses could never threaten Americans. Professor Turley, I'm not an attorney, but perhaps you could give me a little bit of schooling. It's my understanding that if the government wants to go through my papers to search for a document, an incriminating document, it first has to go to a judge, convince that judge there's probable cause to believe that I've committed a crime, and that the evidence for that crime is likely to be found among my papers. Do I have that correct?
That is correct. They have to satisfy the standard of probable cause.
So does it make a difference if that paper they're looking for is in my safe deposit box at my bank?
No, and that's the oddity about this situation, is that because of this new technology and storing on the cloud, suddenly a large amount of your information has become vulnerable to being seized.
Why would that make any difference? It could be seized sitting in my safe deposit box, but they can't just go and seize it. They have to first abide by the protections afforded me under the Fourth Amendment. Is that correct?
It shouldn't. And what they're getting through metadata and other types of searches is a great deal of information that people would believe is private.
My point is, whether I wrote those incriminating words on a piece of paper or wrote them digitally, it's the same thing exactly. Whether I store them at home or in a safe deposit box in the case of a paper, or on somebody's server in the case of a cloud, it makes no difference. It is the same thing.
That's right. And what's particularly bizarre here is that the most famous case of the Supreme Court in the privacy area is Katz, where the court said that the Fourth Amendment protects people, not places. And yet we have the ultimate rejection of Katz, because if you move information from one place to another, it suddenly moves out of a warrant and probable cause protection.
How have we allowed ourselves to get so far from these fundamental Fourth Amendment principles that underpin our liberty?
It's really two things. One is the court opened us up for this when it decided in cases like Smith v. Maryland that pen registers don't require warrants. And a lot of that's based on a myth. The court said, well, you give your phone number to a third party, i.e. the telephone company. Well, it used to be there really was a human being there putting in your phone number. Now, of course, you're giving it to a computer. So people are not giving their information to a third party knowingly. But the court has never corrected that misunderstanding, in my view, of the privacy dimension. The other aspect to this is just new technology. We have constantly seen privacy protections that have failed with new technology. And this age we're living in is making a mockery out of the standards created by the court.
The technology may change, but human nature doesn't change, and the principles that undergird our Constitution don't change because they are rooted in human nature.
And Representative Clinton, I also want to note that there's a growing gap, because the court just decided in Carpenter that you need a probable cause determination and a warrant to get the location off people's cell phones. And all of us celebrated that as a victory of the Fourth Amendment. And yet you don't need a warrant to get information from the cloud. And from a privacy perspective, this is not just nonsensical, it's dangerous.
Yeah. Well, I just wonder, how are secret courts and secret subpoenas and secret letters compatible with a free society? And can a free society exist if its government can secretly surveil its citizens in this manner, in direct contravention of its most fundamental law?
Yeah, and one of the great dangers, by the way, Katz has within it a seeds of its own destruction, because it bases the test of privacy on our reasonable expectations of privacy. So as our expectations fall, the government's ability to engage in warrantless surveillance increases, and that could become this race to the bottom.
And they say this is necessary for our national security, for our country, but the only oath that any public official takes is not to support and defend the country, not to support and defend the government. It is to support and defend the Constitution. There's a reason for that. Our founders understood if we ever lose our Constitution, we've already lost our country.
The time of the gentleman has expired. Mr. Cohen? Unmute your mic.
Thank you, sir. Thank you, Mr. Chairman. Most of the questions I think have been asked that are pertinent, but let me ask this. I'm not sure if this is the right person, because we probably should have the Justice Department before us as well to let us know what's been going on. Ms. Oberlander, do you know of any cases, or do you have reason to believe there are other cases that have not been reported where there have been surveillance that would concern the American public in this committee?
I don't actually have any direct knowledge of any cases that haven't been reported, but I would imagine that there are. I mean, we've just learned about a significant number of attempts to find out the information of various journalists and various other members of Congress. So I don't have any direct knowledge of that, though.
Ms. Oberlander, you're a representative of I guess, the fourth estate, the press, and they are protected by the First Amendment. And we as Congress people are concerned about our Article 1. But the public, as Mr. McClintock and Ms. Lofgren have well discussed, they're the subject we most need to be concerned about. And do you have what are your suspicions on what type of cases and what people have been spied upon through this means?
Outside of journalists? Honestly,
Outside of journalists?
Actually, I mean, I am a representative of the Fourth Estate here, and I am unaware of whoever else may or may not have been spied upon outside of the media.
Well, thank you. Mr. Turley, I think you've discussed some of the exceptions that might be made if we had a law, and I don't know who was addressed it, that we should have, they should all be warrants, and they should be somehow adversary hearings and appealable to some higher level court. Are there other suggestions that you would make to protect the public in these circumstances?
My testimony actually does contain some initial suggestions. It's very important, I think, to address the standing issue. We've had cases in which people, particularly media, have tried to get this issue into court, and they've just been told you don't have standing, which is completely bizarre, because this goes directly to who the media is and trying to protect their constitutional function. There's also limitations on appeal that you can look at. I think you can also, in drafting language, create more of a legislative presumption that applies in these cases to make it clear to courts that the default position should be not to have a gag order. A default position should be not to have these secrecy issues. To give you an example, the important thing here is remember that prosecutors are rational actors. Many are my good friends. I litigate against them, but they are rational actors and they follow the path of least resistance. And if you take a look, for example, at studies with the national security letters, from 2000 to 2005, the number of national security letters went from 8,500 to 47,000. Now, you only have that exponential growth if it is the path of least resistance. You have to make that path a little more difficult.
Well, I agree with you. We need to make it more difficult. We need to protect the citizens. And what concerns me, and I think we're going to have a briefing from the Justice Department after the break, is when did they know the new team, and what did they know about these intrusions on the Congress and the press and the gag orders? Did they only come to the public's attention after the New York Times had reported them? And if so, if they had knowledge beforehand and waited, didn't plan to make this public, then I've got concerns. And I think that I have faith in Merrick Garland. I have faith that he'll change the Justice Department, some of the personnel, to get it to be more transparent. But it would be just disturbing to think that they had this information and only but for the New York Times reportage was this forthcoming to the public about the intrusion into Mr. Schiff and Mr. Swalwell and everybody else, the reporters, otherwise private communication. So I think we've got to go further, but we do need to draft legislation that protects the public, that does put this in front of a court. Mr. Professor Turley, do you think there ought to be is there just one court that issues these, or are there many courts?
I think you can still, the problem is that the sheer number of these cases is just breathtaking. So if you pour all these into a single court, you're going to have a massive court. But judges can handle these questions, but they need more structure from you. I also want to echo, I have faith as well in Attorney General Garland. In fact, I think that he's ideal to deal with this question because he's walked the walk. He's been a judge. He's dealt with these types of docket issues. He's now at the head of the Justice Department. I think that he could be a really terrific ally if he means what he says, and we can try to solve this problem. But in the past, the Justice Department has not been a faithful ally. I must tell you, 15 years ago we talked about this, and the Justice Department was opposed to shield laws and a lot of these provisions. But I do have faith in General Garland. I'm hoping that faith is well established.
Time of the gentleman has expired, Mr. Massey.
In my last, Mr. Chairman, I'd just like to say to Professor Turley, the last time we had contact, I was a little brusque maybe with you, a little rough shoulders. You're a gentleman and a scholar, and I appreciate it, and I apologize if I went too far.
Thank you very much, Representative.
Mr. Massey.
You're welcome.
Thank you, Mr. Chairman. I'd like to associate myself with the comments from Mr. McClintock and Ms. Lofgren that any protections that we provide shouldn't be for a special privileged group of people. I mean, that's not the way the Constitution was written. Ms. Oberlander referred to the press as the fourth estate, which prompted me to look up what are the other three estates. And it's a reference actually not to the three branches of government, but to the three estates in Europe, which were the clergy, the nobility, and the commoners. And I think all of them, including the fourth estate, deserve the protections of the Fourth Amendment. So whatever we draft, I hope it's not just particularly for Congress or for the media. Professor Turley, you touched on something that earlier, but didn't get to spend enough time on it, I think, about the third-party doctrine. And can you explain to us in a little more detail how that came about and what we could do in Congress to sort of rein that back in?
Yeah, quite frankly, I think the Supreme Court has made an utter mess of this area. And I think even people like the late Justice Scalia made reference to the fact that constitutional criminal procedure, which I used to teach, was just an absolute morass created by the Supreme Court. And part of the problem is this idea of third parties, that if you give things to third parties, you don't have that same expectation. They treat things like pen registers, giving phone numbers, almost as equivalent of like Greenwood, of putting your trash on the curb, that you give up all expectations of privacy because you're giving it to someone that you don't know. Of course, when people put in phone numbers, they're giving it to a computer that they assume is subject to some types of regulation. But that has gradually expanded, where the exceptions are now the rule. So you have, with cases like Smith v. Maryland, a lower standard than probable cause under the warrant clause. And what you have to understand is every time the court creates one of these exceptions, prosecutors pour into the gap. And it's not because they are little petty tyrants, it's because they have a lot of cases and they believe very strongly in getting information. They want to get it fast. That's why you've had this massive increase in national security letters, because it's so much easier. You virtually have to show nothing. So it's going to be up to the Congress to make that path a little more difficult, to require showings. But the most important thing is to have some adversarial process and standing so that people like us can come and challenge these things. I do classified work in the national security area, and I'm read into programs so that the judge and the cleared prosecutor and I can argue about evidence. Those are the most extreme possible cases you can imagine. Some of those cases are really classified at the highest level. This should not be so difficult, because this is not highly classified information in the vast majority of these cases. What I think you heard from Mr. Berg is very important. I mean, his company is getting 3,500 requests a year.
Shouldn't the analogy, instead of taking your trash out to the corner and leaving it there and treating your data that way, shouldn't it be more like a safe deposit box? If I put something in the cloud, I have an expectation that you're going to do your best effort to keep it private. Yet we've turned the third-party doctrine, which we somehow are still cling to, has turned that on its head. And I hope we do take that on. I'm going to throw out a couple ideas here. If we were really, really, really serious, we would pass a law that has criminal penalties for those who invade your privacy at the DOJ, FBI, and NSA. And I don't care if it's just $50 fine, and 30 days paid leave, whatever it is. If there was some crime associated with doing this, now the penalty should be much stiffer than that, obviously. So that's one thing I think we would do. The other thing I think we could do is to legalize technical solutions to privacy. Like, it's technically illegal to make a phone call from a location that can't be determined by the government to a location that can't be determined by the government. Why is that? It's technically illegal to have encryption that the government doesn't have a key to. Why is that? Why are we outlawing the technical solutions to this problem? I mean, we're afraid of privacy, but we're clinging to this notion that we can give all the keys to these things to some folks and not supervise them and trust that they won't be rifling through our stuff. So those are just a couple of suggestions. And Mr. Burt, I like your suggestion of making sure that all of the national security letters or the secret requests are eventually, not indefinitely, kept secret, but eventually we know about those, because that's just critical. We got to know what we're trying to legislate. Thank you. I yield back.
Gentleman yields back. Mr. Johnson.
Thank you, Mr. Chair, for holding this very important hearing. We're here today because the Department of Justice has come up short. Recent reports document that in 2020, the Trump administration secretly obtained third-party platform from third-party platforms, the phone and email records of reporters. And this is not the first time or the first administration under which the department has done so. We've heard testimony today that DOJ has routinely misused secrecy orders to avoid basic due process protections in criminal prosecutions. As a country, we've watched presidents as far back as Nixon use the legal system to aggressively pursue the sources of information and leaks. Ms. Oblander, excuse me. Ms. Oblander, what changes should the current administration take to ensure that it does not allow its Department of Justice to overreach in terms of secrecy orders and destroying the ability of the Fourth Estate to do its job, which is to maintain our democracy through free and fair sharing of information that is sometimes critical of government?
Thank you, Congressman. So I think first, I do think it is a great idea to, as Attorney General Garland has said, to basically legislate, to work to legislate that the Department of Justice is no longer permitted to come after journalist source information. But short of that, and I think that would be fantastic, but short of that, I think you should legislate particular higher standards before the Department of Justice can get access to journalist materials. Specifically, there should be, and it should be, again, as people have said, not up to the Department of Justice itself, but it should have to come to a Article III judge, and they should show that the information is absolutely crucial to whatever investigation there is, that they have tried all alternative sources to get that same information and have failed. And there should also be a balancing test by the judge as to whether the information is important enough to outweigh the incredible ability of the press to inform the public about issues of public importance. And so it is essentially it's a very high standard. The judge should have to consider that. And then, as we talked about, the media should be able to have notice of it, to be able to participate in it, to argue about it. It should be adversarial, and there should be a right of appeal. I mean, these are very, very serious rights. that are being, and they should be subject to judicial review. And that would go a long way, frankly.
Okay, do you believe that the Trump administration followed the Department of Justice guidelines when pursuing journalists' sources in the cases of CNN, the New York Times, and the Washington Post that were recently revealed?
Well, the department has said that they did follow the guidelines. We don't know. There's a lot of information we don't know. We don't know what information they put before the court in their warrant applications and the applications before the court to get this information. We'd like to see that. We'd like to see what kind of, why a secrecy order was necessary. As I mentioned, these were records that are years old that they were looking for in public leak investigations that had already been made public. So there was no real, at least from my perspective, there was no real risk that they, having a notice go to the media would have in any way tipped off the subjects of the investigation or allowed anyone to destroy the evidence. And furthermore, this material was in fact in the possession of the third party data provider. It wasn't even in the possession really of the media entities. So the idea that they could then turn around and destroy it is somewhat, doesn't actually make any sense.
And the length of the gag orders in these cases were quite excessive. Would you agree?
I would.
I mean, two years?
The gentleman's time has expired. Mr. Bishop.
Thank you, Mr. Chairman. Mr. Burt, I think it bears repeating something that Professor Turley referred to in your testimony, that Microsoft reviews the number of secrecy orders that federal law enforcement agencies have presented to us from 2016 to the present. We found that while the number has increased some, federal law enforcement has consistently presented us with 2,400 to 3,500 secrecy orders each year, or 7 to 10 per day. Is that correct?
Yes, that's correct.
That's an amazing number, and particularly when you try to imagine what that might be when you go to the other big tech firms. Professor Turley, you have a figure, and forgive me for this ignorance, but you have a figure in your testimony about, and you mentioned that the national security letters have gone from 2000 to 2005, I believe it was, went from 8,500 to 47,000 per year.
That's correct.
And now, here's my ignorance. Would the secrecy order, Mr. Burt, that you're describing be the same? Would that include or overlap with national security letters?
No, Representative, it would be in addition to.
So that'd be separate, right? So in other words, a national security letter sort of there's similar concerns associated with that. That would be over and above what you're talking about, secrecy orders in connection with search warrants.
That's absolutely right.
And are those data published in the aggregate that you know about? You understand what I'm asking, Mr. Burt?
Yes, and the answer is there isn't any reliable source of that information in the aggregate. In fact, with regard to national security letters, we had to sue the government to be able to say anything about that, and the resolution of that was that we can only describe the number of national security letters we get in these broad categories. For example, I can report that, and we do transparently report, that in the last reporting period, twice a year, we got between 0 and 499, but that's the most specific we can be.
How about that? Fascinating. Professor Turley, you spoke about in your testimony, I'm afraid I didn't get it in your testimony before the hearing, so I haven't had occasion to digest it, but you advocate for a shield law. You mentioned the shield, one that's drafted, but you said that it needs to have the definition of journalist modified. As I skim through, it looks like you think there needs to be a broader definition of journalist. But isn't there, and this sort of goes to some of what Mr. Gates was saying, and I think Mr. McClintock responded to, about the possibility of setting up special privileges for an elite class. If journalists are partisan instruments of politicians, or the reverse, that is to say, they direct politicians in effect, if we establish special privileges for them to be able to take information and disseminate it that is by law confidential, doesn't that grant the power to unilaterally not nullify law? If you take the ProPublica information recently, the disclosure of thousands of wealthy taxpayers, some which they've now selectively published, they said, they thought about it, they know this information is unlawful to publish, but they've decided that their advocacy interests trump the law. How do we deal with that problem?
Well, this isn't an absolute right. I mean, the media is subject, for example, to defamation. They're subject to being prosecuted for crimes committed directly by reporters. But what we're talking about is a constitutionally founded privilege. In the critical case of Brandsburg, the court heavily fractured over this question of privilege. There were some, like Douglas, who always believed we should have an absolute privilege. A number of the justices felt we should have a qualified privilege. In fact, most of the qualified privilege statutes are based on the language out of that case. And a qualified privilege just simply gives some added scrutiny and protection to the media. It can be overcome in extreme cases, but it's there to protect this core function of the media. If you take a look at the states, there's 40 states with these privileges. They haven't shut down prosecution. It has not been overwhelmingly burdensome. The judges have been able to use them. And I think the same would happen with the federal system as well.
In the 40 seconds I've got left, can you characterize what is the privilege, what are they privileged to do, and what are the qualifications upon that or conditions?
Well, what the privilege does is it basically gives a full stop for the court. Before you allow reporters to be compelled to turn over information, you have to establish that you can't reasonably get the information from another source, that you have a clear need for this information, where the court's going to balance these interests. Some of these state laws are quite interesting. In New York, they have a different standard. If you go for privileged sort of core news stuff, you have an absolute privilege. If you go for less key material, you have a qualified privilege. There's a lot of states that have explored different types of approaches to this, and it gives you a lot of models to look at.
Thank you, Mr. Chairman.
Gentleman's time has expired. Mr. Cicilline.
Thank you, Mr. Chairman. I think it's safe to say that all of us were very upset when we read the reports detailing how the former President Trump's administration, the Department of Justice, surveilled not only journalists, not only members of Congress, including a member of this committee, but even members, staff, and family. So I thank you for holding this hearing today and giving us an opportunity to really look at the potential abuse of power and particularly the secrecy surrounding these efforts. And, I want to first say I agree with Ms. Oberlander. I think there's a higher standard that ought to apply to the press, and I think that is reflected in the Free Flow of Information Act that Congressman Raskin has introduced, and it's always been bipartisan. I also think making sure these protections apply to everyone is important, and as Mr. Massey and Ms. Lofgren have said, and one easy way to accomplish it, of course, would be to say the Fourth Amendment applies to the data that you generate, that you have a reasonable expectation of privacy of what you create. And all the Fourth Amendment rights would attach to that. But what I really want to focus on in my questions is the secrecy surrounding this, because while Microsoft is an example of a company that takes this responsibility seriously to litigate and challenge this, we have no assurances other companies do the same, and many of these big technology platforms don't have competitors, so if they're willy-nilly giving your stuff away without contesting it, we don't know about it, and we can't choose to go to another platform because they don't exist. They're monopolies. And so I want to really dig down on the secrecy, because I think that's the really one of the important issues here. And I think we don't have a full understanding of what's presented to a court and what the court has to consider to allow these gag orders to be put in place. So I'm going to begin with you, Mr. Burt. What level of details are prosecutors required to provide both the court and the providers when they're seeking a gag order? Do they simply have to say, we meet the statute, or do they have to present facts which show, in fact, disclosure would result in one of the things articulated in the statute?
It's a great question, Representative, and the answer is that today they only have to present to the court this boilerplate assertion that they meet the criteria of the statute and that there's a reasonable suspicion that they can meet that standard. And
no facts underlying that assertion.
That's right. The Justice Department's policy that they articulated in 2017 in response to our litigation said that they should articulate those facts.
Thank you.
But their
I appreciate
their template says they don't have to.
Thank you. Ms. Burton, what about after the secrecy order is lifted and the providers are able to give notice? How much information is shared with the targeted party? And is it required that the information be shared once the secrecy order is lifted?
No, it's not, Congressman. That's one of the problems. I mean, it's an entirely self-regulated process at the Department of Justice. I mean, to take your concerns I agree with you. It is not just a first estate concern, and it is really a self-regulation concern. You cannot have the Department of Justice being prosecutor, judge, and jury. They determine when you get notice, they determine what you know, and you go to a Article 3 court, and you may or may not have enough information, which is why I think you all are very much on the right track to have a procedural set of requirements that are in a statute that it can apply more broadly. And we leave it to judges who now have a standard, and there's notice to the parties, and it's not secret. I mean, we don't allow prior restraints in this country against the press. It should not.
I'm trying to get at a couple of questions. I appreciate that. Thank you. Mr. Burt, once the electronic surveillance-related gag order expires, is there currently an obligation for the Department of Justice to at least notify the target of the warrant that a gag order was in place?
Absolutely not. In fact, they don't typically do that, and so it falls upon us to do that.
And
that's
that
right.
burden that falls entirely on you, are you required to notify your clients or users, or does that vary on a contractual basis?
We're not required to, but we have a firm policy that we do notify in all cases.
Is that same policy in place, to your knowledge, with respect to all the other large technology platforms?
To my knowledge, that policy is not in place with all technology platforms.
And what limited information should the government communicate to suspects, in your view, that their Fourth Amendment rights may have been implicated by one of these orders or collections?
Well, we believe that in those very rare instances where this kind of a secrecy order is justified, and we think the standard should be probable cause, facts should be presented, courts should find that the facts are sufficient. But in those rare instances where it is, where that standard is met, then when the gag order expires, the target should be informed that there was a gag order and should be informed of the scope of the search.
Yeah, thank you very much. And again, it seems to me it's inappropriate for us to expect that third parties are going to fiercely defend the privacy rights of individuals, which this current architecture requires. Some companies take it seriously, some don't, but citizens and users lose as a result. And I thank you again for your testimony. I yield back, Mr. Chairman.
Gentleman yields back. Ms. Spartz.
Thank you, Mr. Chairman. I'm actually kind of listening to all this discussion, very surprised how many loopholes our laws have, and very surprised to hear, our Constitution hasn't changed, thank God. But ultimately, what Mr. McClintock brought up, what's happening, it's really appalling to me. No wonder our citizens are not trusting its government, and it's very bad. I have a quick question, and I think Congressman Biggs brought another good question of rubber stamp, and I will yield him in a second because I would like to finish that conversation. But Professor Turley, just for you, what did allow for us to have these loopholes? Is it interpretation of the courts, or is really something in our legal framework that's so ambiguous that we need to clarify? What is allowed? Because it seems like this due process should exist regardless if we have a new technology, old technology, where we are. What's happened?
Well, it was a perfect storm because you have the court that opened this up, creating a whole group of body of searches that can occur below the probable cause level with reasonable suspicion. That snowballed within a short time. They viewed those as narrow exceptions. It became the exception to swallow the rule. Then you had technology that poured into that gap. That is, it happened to be technology that fell in those areas. And suddenly, we're not protecting people, we're protecting places, or in this case, we're not protecting places like the cloud. So if you take stuff from one source to another, it's protected over here. The minute it goes to a cloud, which you have to use in many cases, or you use as a matter of course, it loses that protection. And I think your point is really the vital one. I think a lot of people be very surprised when they find out that their information is so readily available to the government. And that itself is a very corrupting aspect in a free society, that the public has a different view of what their privacy is from what the government is actively doing, not in a small number of cases, in massive numbers of cases.
Yeah, it sounds more like a surveillance state. We have to deal with that, but you believe it needs to have some legal actions from Congress to be able to remedy this situation?
This is not a particularly difficult problem to solve. It only takes will. You can easily create a framework that will protect privacy and fill this gap.
Okay, well, thank you very much, and I yield to Mr. Biggs.
I thank the gentlelady for yielding. And when we left off, when I ran out of time, Professor Turley just answered my question. I'll just remind you of what it is. and give you the context. I was asking about the stick that might be necessary to help what we typically think of as an independent court. So you all seem to be in agreement with guidelines, et cetera, and statutory guidelines. How do you make sure that those are gonna be tough enough?
If I may, I think.
Yeah, so Mr. Burton, then down the line, then Ms. Burton.
If I may, I think the concept of extending the Fourth Amendment to data that's stored in the cloud is a reasonable framework to consider here, because then that would take all of the existing sticks, as you put it, that would apply when government overreaches and violates Fourth Amendment rights, exclusion of evidence and so forth, and it would be applicable here as well. The irony is that Fourth Amendment jurisprudence is based on this notion of reasonable expectation of privacy. And in fact, your security and privacy of your data is higher in the cloud than it would be if you kept it in your premises or on your network at your corporation. So the technology is not, the law has not advanced with the technology to protect our citizens and our organizations' information.
Thank you.
And just to add to what my colleague here said, one of the reasons that media organizations are putting their data in the cloud is because they are also concerned about the security, and that they can't afford to have the kind of technologists and technologists in their shops who could protect from hacking and phishing and all of the other problems that we have with our data. So it puts them it puts many of the media companies in a really tricky position. But to the point about what kind of penalties you could have, there is the possibility perhaps of a 1983 action if rights were violated, and journalists have used that successfully in certain cases.
And Ms. Burton, before you answer this, I think we all would presume, at least I do anyway, that there's a private property interest. You have a private property right in your data, right? And thus it begs the question that Mr. McClintock and Ms. Sparks were raising, and actually Ms. Lofgren. Why then do we have these loopholes, and then Professor Turley expounded on it, why then do we have these loopholes that attack Fourth Amendment rights over your otherwise well-known, and it should be established, private property interest in your data?
Your time has expired. The witness may answer the question.
If it's to me, the answer.
Ms. Burton.
Ms. Burton, I'm sorry.
I think that the minute we get enough process into a statute, that you're going to see prosecutors act more rationally. And I would leave it to the courts to suppress the evidence and to dismiss cases. I think that, from a prosecutor's point of view, is remedy enough. I'm not in favor of creating lots more causes of action around this. I think we're trying to simplify it. I think we're trying to protect rights. And I think the courts would actually make sure that that occurred.
Gentleman yields back. Mr. Liu.
Thank you, Chairman Nadler, for holding this important hearing. Professor Turley, I'd like to follow up on Congressman McClintock's line of questioning and just walk through some standards and whether judges are involved. So I wanted to talk about the difference between the contents of, let's say, a document versus metadata. So if the Department of Justice wants to get the contents of an electronic letter that is on your home computer, they would need a warrant signed by a judge. Is that right?
That's correct.
If they want the contents of that same electronic letter stored on a cloud, they would still need a warrant signed by a judge. Is that right?
Right. If they get the content, but they can get metadata that can show a great.
No, I got it.
Yeah.
No, let's not confuse things. If they want the content of that electronic letter on a cloud, they would need a warrant signed by a judge, right?
Yes.
Okay. Now let's talk about metadata. First of all, what is metadata?
Well, it is defined by one person as basically data about data. That is, metadata describes data, and that can also then give you information as to the senders, the identification, the subject. That's a lot of information.
Understood. Okay. Yeah. So let's say the Department of Justice wants to get metadata that they believe is stored on your home computer. They would need a warrant signed by a judge, right?
To get access to the computer, that's correct.
Okay. Now, if they want to get metadata stored on the cloud, they could simply send a subpoena and get that data without a warrant. Is that right?
Yeah, and in addition, they make companies like Mr. Burt's company essentially the unwilling participants in that type of disclosure. They're being
Understood.
essentially
So
commandeered.
thank you. Basic question here. Grand jury subpoenas, a grand jury subpoena for metadata. Is a judge involved in that process at all?
For a grand juries can issue for document production at a standard lower than probable cause. Judges are supervising that procedure, but in most cases, these things are issued with very little review, and more importantly, grand jury subpoenas can come under the probable cause standard for document production.
Got it. So let's go back to this example where if you have metadata that happens to be stored on the cloud, there's no longer a warrant requirement. What if Congress simply put in a warrant requirement for metadata stored on the cloud? What's your sense of that proposal?
Well, you could do that because remember, the probable cause standard is not some huge standard. It's actually, as a criminal defense attorney, I can tell you, it's a pretty easy standard for the prosecution to meet, but you have to have clearly articulable facts for getting that type of information. I don't think that the world would come to a sudden stop in terms of prosecutions, but it would make this, you would change the grade a bit to make it a little more of a climb for prosecutors, because right now, this is similar to the false lantern approach in the East Coast, when people would put a lantern to confuse people to think there was safe harbor and this was a lighthouse. So people go to the cloud thinking correctly that the cloud has lots of protection for their data, and it turns out it's a myth that once you do that.
Thank you. Now, I am sensitive to the view that we don't want to sort of draw lines around certain groups of people and not others. I do note that the Constitution specifically talks about the free press. So journalists are in fact in a different category. And the Constitution also does put in just structurally a separation of powers. And when you have one branch, executive branch, trying to intimidate, for example, Congress and seizing all sorts of information, that does pose problems. So my view is that we could, in fact, try to do something different. And Professor, I want to get your thoughts. What if the Department of Justice, when they're getting information on either journalists or members of Congress, they had to provide a notification, for example, to the Department of Justice Inspector General, just as a sort of a second check on exactly what they're doing? What do you think about that?
I think that'd be a great idea in terms of greater transparency, but I want to note that some aspects of this confused me. You have three former and current attorneys general saying they were not aware of this program. That's not supposed to happen. Since the 1970s, either the attorney general or a designated high official is supposed to sign off on this. And so I don't know what happened there, but it's one of the first things I think this committee should try to find out about.
Thank you. And my last question is to Mr. Burt at Microsoft. This increase in these secrecy orders, do you know what the investigations are about? Could it be, for example, about child pornography or something else? Does the DOJ tell you what those investigations are about? And with that, I yield back.
We don't always know what the investigations are about, but we do know enough to know that in the vast majority of these cases, they are just routine investigations that are not about child abuse online or about national security issues, but they're just routine. And I do want to make one thing clear, because I may have contributed to this confusion. When we talk about a standard like the warrant standard, the probable cause standard for a warrant, yes, we have to get a warrant before we produce content. Email, for example, and just a subpoena is all that's necessary to get metadata from us. But what we're here talking about today is the secrecy order that accompanies that warrant or that subpoena. And it's there that we need a higher standard and actual findings of fact to establish that a secrecy order is truly necessary.
Gentleman yields
Thank
back. Mr. Fitzgerald.
Thank you, Mr. Chair. Sometimes I think we're kind of our worst enemies on this, whether it's Congress or as the judiciary was brought up earlier. Could you comment, Mr. Burt and Professor Turley, a little bit about changes or accommodations that have been made under the auspices of either national security or public health when it comes to kind of watering down of how this is viewed?
Joe, sir? Well, there's been a lot of changes. I mean, the interesting thing is this body has shown that it can solve problems, right? You did that with healthcare information. You created added privacy protections. You've done that in creating new limitations on secret searches. All of that can be done if you have the will to do it. What we're really talking about here is not interfering with investigations, but to require a greater level of transparency and proof, but also to allow greater numbers of people to have access so they can raise it. You know, this is a problem that we have a lot in national security litigation that I do, and that is the government often wants to do ex parte in-camera presentations, and I'm in courts screaming bloody murder, saying diplomatically to the judge, Judge, I know you are familiar with this, but you're not familiar with this case. You need somebody who knows what this case is about to spot whether these documents are material. So that's a long-standing problem we have. But the problems we face in classified trials are nothing like what is being done here. Basically, people are told they have no ability to challenge it. Take a look at the Gonzalez case out of the Second Circuit. In that case, the New York Times reasonably said, no, we're not going to turn over our phone records to you, and then called their provider and said, by the way, if they ask for our phone records, please tell us so that we can go to court. The provider said no. No doubt because the Department of Justice said, don't tell them. Department of Justice's position in Gonzalez was the New York Times has no standing to be heard on this issue to appeal this question. In what universe of due process would that seem reasonable to you?
Mr. Burt.
And I would just add that what we've seen happen over the last 2-3 decades is that tools that were provided to law enforcement to address a particular problem and a particular concern, especially around national security, have now been overtaken by technology and the way that people keep and store their data. And those tools have now not been restricted and limited in an appropriate way to protect individual rights as technology has moved data from, say, on-premises into the cloud. And that's what we're seeking here is a restriction on those tools that still enable the kinds of investigations that are truly necessary to be conducted for a brief period of time in secret, but that in most cases enable notification to our customers when their data is being obtained.
Thank you very much. Professor Turley, let me get a little more specific and down into some of the issues that had been discussed earlier by some of my colleagues. 2017 report by Chairman Ron Johnson of the Senate Committee on Homeland Security and Governmental Affairs found that the Trump administration was facing about 125 leaked stories, about one a day. And the report concluded that the leaks with the capacity to damage national security, which is kind of what I was trying to tee up earlier, flowed faster under President Trump than during President Obama and even George W. Bush. Why is this problematic? Why was there a difference between administrations? And ultimately, you know, this misleading narrative that's been out there needs to be addressed. I'm just wondering what comments you might have on that.
Well, frankly, I've never seen leaks like the ones we saw in the Trump administration. I mean, they were occurring so frequently, it was almost like you were getting leaks in real time. I mean, there was, you know, you would get leaks about meetings that just happened. And that obviously can't happen. You can't have a functioning presidency if you think that whatever you told a world leader or your aides is immediately going to be heard on CNN or Fox. The government has legitimate reason to hunt leakers. My objection is what I call reverse engineering. Nobody, I think, can contest that the Trump administration would announce it was going to go after leakers, had every right to do that, to go try to find out who was leaking unauthorized information. But what concerns me is that it's always tempting for prosecutors to reverse engineer. They know who received information. Just look at the byline on the article. That's the person who is the recipient. And so you can reverse engineer by just focusing the investigation on the reporter and then working back to the sender. That's a very dangerous approach. It's dangerous for the Constitution. The preferred system is to look at the suspects, but in the process of that, you're going to find out the numbers of reporters. You have to, otherwise you're going to stop all leak investigations. But it's where you start, and my suspicion is this might be a case of reverse engineering, which I'd love this committee to confirm.
Gentleman's time has expired. Mr. Raskin?
Thank you, Mr. Chairman, and thanks for calling this hearing in the immediate wake of revelations that the DOJ sought the telephone and email records, not just of journalists, but also of two of our colleagues, Mr. Swalwell and Mr. Schiff, as well as even family and staff members, apparently. I want to thank the witnesses for helping us examine the threat specifically posed to the freedom of the press by these practices. I think it's a matter of fundamental importance to American democracy, and I'm pleased to note that tomorrow I will be introducing the Press Act, the Protect Reporters from Exploitative State Spying Act, which I've been working on with Senator Wyden for some time, along with my colleague, Mr. Liu. This bill is an update of the Free Flow of Information Act that I proudly introduced in the last Congress with our colleague, the ranking member, Mr. Jordan, in the 115th. It will prevent federal law enforcement from being able to obtain information from covered journalists through their work devices and accounts, as well as their personal devices and accounts, and will also prevent the government from conducting an end run around these prohibitions by preventing them from seeking third-party communications held by computing and communication services, except in narrow exceptional circumstances. I hope that colleagues on both sides of the aisle, as demonstrated by what appears to be broad consensus today, will join us in co-sponsoring this bill and work to defend the freedom of the press against these practices. Ms. Burt and Ms. Oberlander, I'd appreciate it if you could expound on the need to address the secrecy orders being used by law enforcement to prevent targets from even being aware that their information is being sought, and what type of oversight the court should be conducting to rein in the abuse of secrecy orders.
Thank you, Congressman. I would suggest that by having, again, a narrow procedural bill which says that there cannot be a secrecy order without a compelling interest that's been identified, been presented to a judge very specifically, and a judge has actually made a ruling. And that if we did that, you would see very few secrecy orders, because before we had this back door that everyone was going through, it wasn't a problem at the same levels that it is now. So I would just suggest that if we have proper and clear requirements that there is a bilateral presentation to a court, either through the judiciary, which would create some opportunity to hear the other side of a argument if something really was a national security issue, a very narrow set of cases, that would probably resolve the secrecy issue.
And then the secrecy order would go back to being an exceptional
exactly.
case rather than the rule now, because it seems to be pretty perfunctory that they get them now, right?
That's right. It's having a dual process, and it's having a presumption in favor of openness that judges respond very well to in light of all the constitutional rules and cases that have upheld those basic cadence.
Okay. Did any of the other witnesses want to comment on that?
I would only add that there are a couple other things we can do too. So you can narrow the, as we've discussed, narrow the length of time that the secrecy orders are in effect by putting a cap on them in the statute. Right now, in 2705B, there's no time limit, so you add 45 days or 90 days, and that's it. You then have to tell the subject, the media entity, that their materials have been requested. That would help as well. And then the other thing that has been presented in some of our testimony is that in cases where it's truly necessary to not inform the affected media, maybe we can have an independent third party, some sort of advocate, perhaps who doesn't necessarily let the media know that they've been hired, but who comes in and talks to the judge and says, these are the First Amendment, these are the very, very important First Amendment interests here, and you should please be considering them. So adding sort of another advocate to the process.
Let me just stick with you for a second. You noted in your testimony some of the policies that are being used by DOJ to limit the use of subpoenas against journalists, but you observed that these are merely internal policies that are subject to override at whim by future administrations, and they don't address the end runs that are being conducted routinely by law enforcement to obtain third-party data from companies like Microsoft, as noted by Mr. Burt. I wonder what do you think about the need for a press shield law, given everything that we've learned in the last few months? And maybe I can close just with that question to all of the witnesses.
am delighted to hear that you're introducing the Press Act tomorrow. We absolutely need a shield law, which will frankly protect from government overreach, but also in private cases as well, and civil cases. And so I really think that we absolutely need it, and I'm really thrilled to see that Congress is working towards it.
Just if I could go down the line there, Professor Turley, do you agree we need one?
Oh, I do agree. The only quibble I had in my testimony is it's more than a quibble, but is a disagreement about the definition of covered persons. I also think that it can be tweaked to increase some issues. For example, there's a single line on national security may be considered by a court. That's in the previous legislation. And it really doesn't say how that should be weighed by the court. I expect a lot of judges would look askance at that as a standard.
Okay. And Ms. Burton, do you agree?
I agree, but I wouldn't let that process, which will be a longer process, stop this committee from issuing a bill and a law right away. I think that we cannot underestimate the harm of privacy and the harm of a lack of process here, which to me is incredibly dangerous to the American public. But I do support a shield bill. I think it's a more complex discussion, which we should be reflecting on also.
Thank you. I yield back to you, Mr. Chairman. Thank you for your indulgence.
Gentleman yields back. Mr. Jordan.
Thank you, Mr. Chairman. I want to thank the chairman for putting this hearing together today on this important subject. And I was just thinking about, in a kind of a broad sense, how serious this situation is. Americans have a Fourth Amendment expectation of privacy regarding all their information, including, as we've talked about, information stored in the cloud. Yet government can come to a third party, like Mr. Burt's company, and with something less than a warrant, get that information. And when government does that, they tell Mr. Burt that he can't tell his customer what's going on. He can't tell his customer that, hey, your Fourth Amendment liberties have just been violated. And when government initiates it all, the Attorney General doesn't even sign off on it. Now, if that's not serious, I mean, the current situation that brought us here is the situation that has been in the press. And we've had Mr. Barr, as I think it's in Mr. Turley's testimony, he says, very first point, the authorization, it's notable. I'd say it's more notable. I said it's shocking, it's alarming that Jeff Sessions, Bill Barr, and Merrick Garland all deny any knowledge of what took place. Somebody had to sign off on it. So you got the fundamental issue at stake here, and you got no one who's been Senate confirmed, which is part of our checks and balances on protecting our liberties, who's even signed off on this. So I find this, as Mr. Gates, I think, led off on our side, the idea that we can work together on this, Mr. Chairman, and do something, whether it's the shield law that I've co-sponsored in the past with Mr. Raskin or what have you, but that is the situation. And I'm just curious, Mr. Burt, has it happened to the same customer several times?
I'm sure it has happened to the same customer several times, although I can't say that with any specificity, but I'm sure it has happened.
So it could be even worse than I just described.
It could be. One thing of Congressman is that one of the things we always do when we get these processes, we look to make sure that it's adequate. We will not produce our customers' content, our email or other content data without a warrant. We require a warrant, but we still get subject to the secrecy order, so we can't tell the customer that their data has been taken, and only the customer can actually exercise their Fourth Amendment right. But you can't exercise your right if you don't know it's been violated.
And even when you suspect it might be, and they tell you, as in the Gonzalez case, which Mr. Turley has cited, they can specifically tell you, no, you can't even, they can't do it. There's no way to go make your case and be an advocate and do what you need to do in a court.
That's right. The court would say we don't have standing on the Fourth Amendment issue, and we would be told we don't have the right to tell our customer that they should go look to see if their Fourth Amendment rights have been violated.
Okay, so Mr. Turley, what should we do? This may be the first time this committee, this Congress has actually kind of had some kind of agreement on, maybe we can work together on something. So tell us steps 1, 2, and 3, what you think we should do. Because I do think, I mean, the idea that Mr. Raskin and I, who don't agree on a whole lot, agree and we've co-sponsored this legislation, I think is telling. And you've heard the comments from both sides. So give us the 1, 2, 3 that the Congress of the United States should pass.
Well, putting aside the shield law, which we discussed, I note there are 6 areas I think you should look at, but I think that you need to strengthen these standards. You need to give courts more concrete standards, give standing to companies like Microsoft, like New York Times, to be able to contest these issues, to limit these types of agreements. You got to stop relying on the goodwill of the Department of Justice. The Department of Justice says that these types of orders have to be, quote, extraordinary measures, not standard investigatory practices. But if the reports are true, as what we've been reading about, then that and a buck will buy you a cup of coffee. It was not worth, you know, the paper they wrote it on. You need to establish concrete standards that can be appealed, and that the critical parties of interest can be in that room. And then we also need greater transparency on how many of these things are being issued and their conditions. You have a number of courts that have complained in writing that they're getting nothing but boilerplate language from the Justice Department and little ability of the court to say no.
Great. Thank you all. Mr. Burt, do you want to?
Yeah, we detail in my written testimony the steps we think the committee should consider, but I could just emphasize a couple of them as really critical. First, the restriction on us telling our customer is a restriction on our First Amendment right, and a number of courts have recognized that, which means that the standard of a secrecy order should be a strict scrutiny standard, but that's not being applied. So the corrective legislation would be clear that strict scrutiny should be applied and that there must be findings by the court based on compelling evidence submitted to the court showing that that standard has been met. And even then, these privacy orders should never be longer than we propose 90 days without clear evidence being shown later on as to why they should be extended. We think just those steps would significantly reduce the number of these privacy orders that are even sought and would certainly reduce the number that are being granted and confine them to those cases where they are truly necessary in the national interest, because they would have to show to get that privacy order that they can meet one of those 5 statutory bases for getting a privacy order, which are reasonable reasons to proceed in a short-term private secret way.
Gentleman's time has expired. Mr. Jeffries.
Thank the distinguished chair for holding this hearing, as well as the witnesses for your presence here today. Clearly, in the constitutional construct of this country, we've got an Article I legislative branch that I'm very proud to serve in, Article II executive branch, the Article III judiciary, all apparently constructed to make sure that there are checks and balances, but also I think the framers of the Constitution recognize the importance of a free and fair press. It's in the First Amendment, the first decision made to amend the Constitution, recognizing that perhaps a fourth estate was also central to their vision as to what the Democratic Republic would look like were we able to keep it. So I just wanted to ask a few questions, and Ms. Oberlander, I'll start with you. Throughout your career, you've advised media companies and journalists, I believe, on the legal implications of reporting on matters of public concern and national security. Is that right?
Yes, that is.
And in your view, how has the government's use of what I would phrase secret subpoenas and gag orders threatened the ability of journalists to actually do their job?
So journalists who are afraid that they are being surveilled, or even that they have been surveilled in the past, or then it's very difficult to go and convince or talk to or be able to fairly represent to a source that they will try to maintain their confidentiality. It's quite chilling. I mean, some of it is on the source side, where they see that the journalists have been subject to subpoenas after the fact, and they said, I can't talk to you, and it makes it very, very challenging.
Is it fair to say that in providing information to the public, which is a great service that the media, the fourth estate, that journalists provide, that they often will rely on confidential sources? Is that right?
Yes, there's a lot of reporting, outside national security reporting, but also all sorts of other very important reporting that relies on confidential sources.
And can you elaborate on the importance of maintaining confidential sources without sort of this practice being chilled by an overbroad or overly aggressive Department of Justice utilizing these secret subpoenas to
Well, so
try to
yeah.
unroot these sources?
Yes, I mean, if you, there is, in our papers, in the testimony, you can look at all sorts of incredibly important stories of really national importance that were based on confidential sources. Some were, in fact, national security stories, but others were conditions at Walter Reed, levels of corruption in foreign governments. In fact, frankly, as a person who has worked at Univision, I can report that there's an awful lot of reporting about what's happening internationally with other governments, not the American government, where you have very, very important reporting coming through and where the sources are literally afraid for their lives. And so if you cannot maintain their confidentiality, if there's a risk that they're going to be disclosed, then they really are, they may be killed. They have very legitimate fears of retaliation. That, of course, fortunately, we tend not to have killed too many journalists or sources here that I'm aware of in the U.S., but it's definitely a big part of our reporting. Similarly, you know, there have been reports, much reporting about all sorts of fraud in H-2A visa applications, things that are relying on confidential sources, people who don't want to be disclosed because they may be here, they may be undocumented, but they still may be subjected to quite horrible conditions. The Enron reporting, the Balco reporting, and just now even the reporting about the tax filings of wealthy Americans.
Now, in justifying what some of us may characterize as overly aggressive and/or inappropriate behavior at times, Department of Justice or other governmental entities will sometimes cite national security. And that's a very broad phrase, and we certainly all are concerned about national security. But in your experience, can you just, in the final few moments that I've got, articulate whether that is being invoked in an overly broad fashion, and how might we think about viewing and balancing national security as a concern, but also allowing the free and fair press as vital to our democracy to also be able to thrive?
Time of the gentleman has expired. The witness may answer the question.
So there's a long-standing problem of overclassification of information in the country, and because of that, if a source discloses some information that is classified and maybe gives the government an opportunity to argue that that disclosure is a violation of one of the Secrecy Acts or the Espionage Act, you all of a sudden have a national security issue when really much of that information is not of that kind of importance, where you would be disclosing something truly secret and dangerous to the country. And so one way of restricting it is to restrict the definition of national security in any of the statutes that we pass. In terms of what would qualify for an exception, and to narrow it, maybe, as has been proposed, just to include terrorists and potential terrorist acts, a really dramatic issue, and not just a level of embarrassment to the government. That would be one approach.
Mr. Bentz.
Thank you, Mr. Chair, and thank all of the witnesses for their excellent testimony and their doubly excellent testimony as it appears in my notebook here. We had a 25-hour marathon discussion about big tech just last week, and much of that discussion focused on eroding thoughts about privacy. So, Professor Turley, I think you mentioned that the reasonable expectation of privacy perhaps isn't as reasonable as it once was, given what we're now doing. So, your awareness of that space leads me to ask you, what is our new standard? What's the alternative if none of us should expect privacy anymore in this dual life we live, one online and one sitting here today?
Well, I think that is the danger, that we could move towards a post-privacy world, and that's something that none of us wants to see happen. The CAT standard is unlikely to change, but it means that our protection from government surveillance is based on our reasonable expectation of privacy. And as that expectation falls, the government's ability to engage in warrantless surveillance increases, and that can make expectations fall further. This is the ultimate example of that. People store a great deal of their information on the cloud. As they begin to understand that what they send in messages in terms of metadata is not protected, and phone numbers are not protected, and all these other areas are treated as just subject to the standard of reasonable suspicion, which is barely a speed bump for prosecutors, their expectations will decline further. And what worries me is, I tell my students this all the time when I teach privacy at the law school, is that my students' expectation of privacy is a fraction of my own. And we're seeing this decline in generations, but it has real impacts on government ability to engage in warrantless surveillance. That's why this is an occasion where the Congress actually can correct the error of the courts, can come in and say, we actually don't want to live in a post-privacy world. There's new technology here, particularly on the cloud, and we're going to protect it, because if we're really serious about cats, that the Fourth Amendment protects people, not places, then go protect people. You find them in the cloud in terms of what they are leaving there. And then you would actually defend cats, I think, more than the Supreme Court has done.
Thank you, Professor. Let's move to Ms. Burton. And on page 11 of your written testimony, you note that there had been a constitutional violation, I think the way you've put it, of preventing a lawyer communicating with their clients by virtue of one of these gag orders. Are you familiar with any other situation where such a prohibition has occurred, where a lawyer has been told by a judge, you can't talk with your client?
No, I'm not aware of one, Congressman, and I think it's a clear violation of prior restraint laws and the attorney-client privilege laws. And if I'd been subject to that, I would have brought a separate action in the courts to have that vacated. But obviously, that's not something that you shouldn't need to do. It should be part of continuing legislation that we're considering today.
Right, and at the bottom of the paragraph, your last sentence, you state, any legislation should clarify the extraordinary presumption against such orders and the heavy burden the government must bear to justify one. Would you describe how, or tell us how you would craft the definition of that heavy burden?
Yeah, I mean, I think there has to be a compelling interest before any kind of secrecy order can be imposed. One of the things we've done is we have contractual provisions with all of our cloud providers that require them to give us notice. So that has actually helped, which tells me that if we were to add some language into statutes, we would have the same benefit of that. The government will typically go to whoever's easiest to get the information from. And if there's a battle over contractual provision, I give credit to Microsoft. They've been very good at giving us notice, but that's not the case in all of our communication providers.
Thank you, and thank all of you for your patience, and yield back.
Gentleman yields back. Mrs. Swalwell.
Thank you, Chairman, and thank you for holding this hearing. And as we look at the last administration and the abuses at the Department of Justice, it's clear that we had a president and a department that rewarded the president's friends, reducing the sentences or issuing pardons for Paul Manafort, Roger Stone, Michael Flynn, and then punished and weaponized the department to go after the president's enemies. And I guess I'll start with Ms. Oberlander. If you would engage me on this, would you agree that presidents set the tone for a country, that how a president engages, whether they're a bully or they're compassionate or they're a leader, has a real effect on just how everyday Americans can carry themselves?
I would, and I do think that the attacks on the media of the last administration has had a profound and negative effect on how the media is perceived by all of Americans. I think the cries of fake news and the specific attacks on particular journalists has really undermined and worked to really injure the standing of the press.
Ms. Oberlander, you're correct, and we've seen at the Trump rallies, the attacks on the media. We've seen across the country attacks and violence against journalists. And you did not know my questions ahead of time, and Mr. Chairman, this is not an advertisement for my violence against journalism bill. But Ms. Oberlander, my concern, aside from what Donald Trump and the department did, because I have faith that Merrick Garland is going to get to the bottom of this and that in Congress we will understand exactly who was responsible. To kind of extrapolate what you were saying, the Department of Justice is not the only law enforcement agency in America. Is that right?
I think that's correct, yes.
In every state, you have a state attorney general and, of course, county and municipal law enforcement.
Yes, you do.
Do you fear that if you have a president who detests accountability and was willing to weaponize his own law enforcement agency against his enemies, that could have the effect, just as we mentioned earlier, with presidents setting the tone, of governors and mayors seeing it as a permission slip to weaponize local law enforcement? I
think, well, I do want to say that the subpoenas to the media have been going on across. This is not a partisan issue. I mean, we did see that President Obama issued a number of. There were more leak investigations than there had ever been, and that's we've had a growth of that. So it's not purely a political issue, but yes, the attacks on the media have had an effect both federally and at local and state jurisdictions. And if you look at there's been a lot of video of how media, who were labeled media, press, et cetera, were treated and injured during some of the protests last summer. It does feel that in some cases they were singled out because they were press.
And to distinguish, because I agree with you, it was wrong that the Obama administration allowed that, but would you agree that while that was an aggressive pursuit of leaks, the difference between what we have seen or suspect with the Trump administration is that it was a punitive use of power, meaning it was the motivation was to go after perceived enemies, whereas on the Obama administration side, it seemed it was an aggressive use of law enforcement. Wrong, but I think there is a distinction.
There's absolutely a distinction between the way the administrations operate. I wouldn't want to characterize, one motive or the other on that front. But I will say that there has been during the Trump administration, we believe that there have been twice as many leak investigations opened up as there were in the prior administration.
And Ms. Oberlander, I don't want anyone to walk away from this hearing believing that members of Congress think that they are above the law. If a member of Congress commits a crime or if there's probable cause for a search warrant, he or she should have their records subpoenaed or their property searched and seized. But what can we do aside from additional protections for journalists? What can we do for non-journalists as far as additional protections?
So, and I completely agree, and I will say that even the shield laws that we've looked at, and also all of the Attorney General guidelines, I do want to point out that if a journalist is suspected of committing a crime not related to news gathering, that the crime is not itself growing out of the news gathering, then none of these protections apply. The government can come after and look for their materials and see if so there has always been an exception, the carve out for crimes that have nothing to do with news gathering in all of that. But I do think that for everyone, I do think there should be, at the very, very least, and this applies to members of Congress, a duty of candor on the part of the department that anytime they are looking for materials from a congressperson or their staffs or their family, and they know whose materials they're looking for, they need to tell the third-party provider, the service provider, of whose information it is. Apple has said that they had no way to identify, essentially, that they didn't know that this was congressional staff and families. So I think there should be a legislative obligation to disclose, what they know and why they're looking for it, and then And then in the limited, very limited places where there is no notice given, the service provider will be able to make a determination of whether that's something that they should be objecting to or not.
Great.
The gentleman's time has expired. Mr. Johnson.
Thank you, Mr. Chairman. I appreciate our witnesses, but I have to use a few moments here to address the elephant in the room. I'm here at the southern border, La Jolla, Texas, participating remotely because we're here with President Trump, with Governor Abbott, and about 24 members of Congress to highlight the crisis here. Mr. Chairman, I have to say, our committee, the House Judiciary Committee, has jurisdiction, broad jurisdiction, and this is the most pressing issue facing the country, and it's being totally ignored by the committee. We have to point that out. Last night, Mr. Chairman, we were on the border until probably 1 or 1:30 in the morning. We watched just droves of migrants in caravans coming across the border all night, completely undeterred, because the border wall construction was stopped there just south of La Jolla. There's a big gaping hole, and there are many, of course, all across the southeast Texas border. We appreciate Vice President Harris finally making a trip to El Paso, but that is not where the crisis is at its apex. It's here in South Texas, many hundreds of miles south of where the Vice President went. The House Judiciary Committee has a responsibility to address this crisis. We had 180,000 plus encounters at the southern border just in May alone. It is a record increase, and it is a crisis. We saw small children abandoned last night at the border, walking across unaccompanied. The Border Patrol Customs and the Border Patrol Protection, the agents here, are so frustrated because they can't stop it. All they can do is work as processing agents for the cartels who are trafficking humans into this country. They take them to a facility. Most of them are not COVID tested. They give them travel arrangements, and they're sent into the country to all points, all 50 states apparently, with no expectation that they'll be tracked or returned at all. This is a humanitarian crisis. Oh, by the way, fentanyl seizures are up 934 pounds at the southern border alone, just in May, a 300% increase over May of last year. This affects every state in the nation and every American ultimately, and it is an outrage. It is a dereliction of our duty. I'm saying to my colleagues on both sides of the aisle, we must address this. The Republicans on our committee have introduced legislation to fix this. I've got a number of bills myself to help with the asylum reforms and all the things that we know need to be done, but they have been ignored. And I just want to go on record and use my time this morning to say we will be highlighting this today on the border. We hope that the media covers this and shows the American people what's going on. And I think, very frankly, and I say respectfully, Mr. Chairman, it is a shame the Judiciary Committee is not doing anything about it. I will yield back my time because I'm about to go to the border here, and we need to talk about this, and we need to have a hearing immediately. I yield back.
Gentleman yields back. Ms. Jayapal.
Thank you, Mr. Chairman. I hope Mr. Johnson will ask Donald Trump why he separated thousands of children from their families, and I hope he asks him why the Department of Justice under the Trump administration undermined the civil liberties of so many people across the country with these secrecy orders. I wanted to pick up on, I believe it was Mr. Cicilline's questions about what is needed to get these protection orders. I think that this whole process is really quite stunning for most Americans who don't distinguish between what happens to their data that's stored and what would happen if they were to be in their home and their files were to be seized. And so I want to just read from, this is a U.S. Department of Justice Office of the Deputy Attorney General memo from October 19th, 2017. And in the footnote, it says, when applying for a 2705B order to accompany a subpoena seeking basic subscriber information in an ongoing investigation that is not public or known to the subject of the investigation, stating the reasons for protection from disclosure under 2705B usually will suffice. And it actually just puts a point on, I think every one of you in some way or another has commented on this. I think Mr. Turley, you were speaking to this as well. It's quite stunning to me that there really seems to be no standard at all. So of course the courts are not going to get any information because the direction is you don't need to provide it. And so I'm wondering on a scale of 1 to 10, of 1 being a rubber stamp and 10 being
a real process that protects our civil liberties, our rights. Just curious where you would put the current standard, and we can just go through quickly, Mr. Turley.
I put it at a 1, and I really compliment you for highlighting that footnote because it is how it reads. It's basically telling prosecutors, confine what you say. You don't have to give any details. And the Department of Justice benefits from that, right? If you can use boilerplate and use it over and over again, then judges, when they see it, basically say this is all they have to show. And that's how you get to these high numbers in terms of the use of these devices.
Mr. Burt?
Yeah, I would agree that it's a 1, and while there's that footnote, that same policy, which is the one that emanated from our litigation against the department, says that they're supposed to articulate facts. But then when you look at the template that the Department of Justice provides to the 93 offices around the country that says, here's how to get these secrecy orders, it says, just write down this boilerplate. So the actual form template is consistent with the footnote, and there's really no meaningful process.
Ms. Overlander?
I mean, I don't have a lot of exposure to these, only the ones that have been reported, but certainly for the ones that have been reported, 1 or 2, it's pretty low.
Ms. Burton?
I put it at a 0. Yeah. I mean, this falls into the category of a ham sandwich can be indicted. This falls into, the government calls the shots, and that's the end of the discussion. That goes to a 0 to me.
I object. I wasn't given that option when I took the test. But
You stuck to the instructions. Now, let's say, Ms. Burton, I'll just stick with you on this one. Let's say that the extension is obtained, and then the very next day, the case is dropped because there's not enough, there's not enough evidence, whatever. What happens to the extension? Does the DOJ go back and say, oh, actually, we don't need that extension anymore? Can you give us some knowledge about that?
Yeah, I mean, we have a case where, 15 years ago, very, very beginning of cloud computing, it is still a sealed proceeding. I mentioned it in my testimony. So I think this is a critical problem. You've got to have a sunset provision at the very least. But, again, if you have Pentagon paper type standards before you can even enter into this kind of a secrecy order, you aren't going to have a big problem. I mean, national security and secrecy orders are a very small percentage of what we're talking about.
Right.
So I think you would have a sunset and a small problem.
So, Mr. Burt, I was struck by the data of Microsoft receiving 5,500 requests just in the first half of 2020, and your company turning over basic data to 54% of the requests. Compare that to the New York Times reporting that Apple turned over basic data in 43%, Google turned it over in 83%, Facebook turned it over in between 85 and 89%. And it seems to me that we are essentially depending on tech companies, in this case, to negotiate the civil rights and civil liberties of their users. Why is it that your rates, and if Apple were here, I would ask them as well, were so much lower? It seems to me you take this very seriously in how you move forward with these requests.
Time of the gentlelady has expired. The witness may answer the question.
Yes, well, we do take it very seriously because we think it is our obligation to protect our customer interests here, and because we do believe this is a First Amendment violation, a restriction on our ability to inform our customers when the data they trust us to hold securely for them has been taken by the government. But somewhat in defense of some of my competitive companies, you also have to understand that different companies have different categories of data. And so we have a lot of what has been referred to as metadata. And often what we get is a subpoena for that metadata, then accompanied with a privacy or a gag order. And so our percentage about how often we provide content versus metadata is in part a reflection of the volume of accounts where we do have metadata, whereas a social media company, for example, that metadata might be less interesting to the government. They might be more interested in the content of the postings. I don't know because I don't represent them and I don't see the demands that they get, but there are possible explanations other than just how seriously we do take our obligation.
Well, thank you for taking it seriously. I yield back, Mr. Chairman.
Gentlelady yields back. Ms. Scanlon.
Thank you, Mr. Chairman, and thank you to all of our witnesses for speaking today about
these really important issues surrounding the DOJ's extraordinary use of its investigative powers to seize materials from members of the press, members of Congress, and their staff and families. As a lawyer and someone who's proud to represent Philadelphia, I had to note Ms. Oberlander's written testimony where she talked about the fundamental values underpinning the First Amendment and the uniquely American principle valuing a free press. The first strong expression of that principle arose during the John Peter Zenger trial, which occurred before the Constitution was even written. That case stemmed from Zenger's refusal to disclose the sources of articles critical of the British government that he published in his newspaper. And of course, it was the brilliant Philadelphia lawyer, Andrew Hamilton, no relation to Alexander, who represented Zenger in that case. Hamilton argued for the critical importance of a free press to preserve our liberty by exposing and opposing tyrannical power by speaking and writing truth. And those principles were written into the Constitution. How striking that almost 300 years later, we're still addressing the same issue, the need to preserve the ability of a free press to protect its sources, particularly from a vengeful or tyrannical government that's trying to prevent the press from speaking and writing truth. Now, Mr. Burt mentioned the problem that when data is obtained under a gag order from Microsoft or other platforms, they can't raise the Fourth Amendment protections because those belong to the individuals whose data is being seized. But then we have this catch-22 because they also can't tell those individuals that their data has been seized and thereby give them the right to assert their Fourth Amendment rights. And as I understand it, the workaround here that some news agencies have been able to implement is that they have contractual provisions that require the tech platforms to notify them if the government seizes the data, but then the gag order extends to the attorneys as well. So we still have this problem. Do I have that wrong? Mr. Burt, you're shaking your head.
Yes, it's not quite right because the media companies, we do disclose when we can, and we have customers, including some media companies, that have very specific disclosure obligations written in by contract because, as pointed out earlier, we don't have an obligation to tell our customers when their data has been subpoenaed or obtained by warrant, but we do it as a matter of policy. So some of our customers say, well, we want that in the contract, and we agree to that, but it's always subject to the secrecy order. And so we can't inform the media company's outside counsel, we can't inform anyone, even within the company itself, within Microsoft, we're restricted as to who can know about some of these secrecy orders. So that it's not a workaround for this problem. For the press to exercise its right to be a free press, they have to know when their data is being taken by government, and we can't tell them when we have a secrecy order.
Ms. Oberlander, you discussed the fact that the construct as it's being used now creates issues with respect to attorney-client privilege. Is that right?
Well, yes, I mean, certainly as when you just extend the secrecy order to the in-house counsel and you don't let them tell their client, yeah. Or to their outside counsel, for that matter.
So does that impede the free press ability to collect data, et cetera? How does that impact?
So, I mean, it really, well, first of all, the attorney can't do what they're hired to do, which is to give advice to their client. They can, in some ways it's better than nothing because they can in fact hire, if they're permitted to, outside counsel who can go and try to make their position known to the government, which is what happened with these gag orders that we've been talking about. But it's very, very limited. And it also creates, just in terms of the client relationship, if your client doesn't think that you're telling them the truth, or that you know something about their work, then there's a level of distrust there that can poison the entire relationship going forward.
So it sounds like these processes create a corrosive impact upon the whole system.
I believe it does, yes.
Mr. Turley, you mentioned that the current DOJ procedures require senior DOJ leadership to sign off on these secret subpoenas. Is that correct?
Yes, that's correct.
And as you noted, the three most senior officials at the Department of Justice during the relevant time period, both former Attorneys General Sessions and Barr and Deputy AG Rosenstein, all deny that they signed off on the subpoenas in this arena. Is that right?
That's my understanding, yes.
So do you think the process failed, or are these answers from those officials disingenuous?
Well, that's the first thing I put in my testimony is for this committee to confirm, because it doesn't make sense to me that that standard of a high level of approval was put in the 1970s as part of reforms overall. Then after that controversy during the Obama administration, it was ramped up again. That was reaffirmed that you need that type of sign-off. This is one of those things that sort of should make the sand bounce over in the Department of Justice. I mean, if you're coming up with a search that's hitting on journalists or members of Congress, you would think that would go straight to the AG's desk. And I believe these AGs, they don't have any recollection of approving this or being informed of it. That's the first thing that I think the committee needs to determine, because if that's true, something seriously went wrong here.
Okay, thank you. I see my time has expired, and I yield back.
Gentlelady yields back. Ms. Garcia.
Thank you, Mr. Chairman, and thank you for putting together this wonderful group of experts to visit with us on this very important topic. Like many Americans, I was alarmed to learn that reportedly the Trump administration seized records from Apple to obtain, and others to obtain phone and email records belonging to some of our very own colleagues, their families and their staff. I mean, it was outrageous. And then also from news reporters, which again is outrageous behavior. And it appears now from some of the testimony we've heard today that more often than not, gag orders were sought from the providers to make sure that they could not alert anyone. To me, this is a blatant abuse of power. During the House impeachment investigations and trials of Donald J. Trump, I constantly reminded my colleagues and all Americans that democracy is a gift that each generation gives to the next. We must protect that democracy, and we must do all that we can to stop this kind of behavior. Former President Trump has time and time again placed his own personal interests above the American people. And it appears that he did that in this case too. My colleague, Mr. Sawwell, who looks like he was a target of these attacks, mentioned that earlier. It is again looking at and wanting to get some of his critics. It's evident that our founding fathers vested the power in Congress for oversight. So I am so glad that we're doing that today. Congress and the American people deserve the right to know whether these unauthorized disclosures of classified information were properly predicated and approved. I've said it before and I'll say it again. Nadie está por encima de la ley. No one is above the law. I'd like to start my questions with Ms. Burton. Ms. Burton, you mentioned in the 3 or 4 things that you would seek in reforms, which I think it's just very refreshing that it appears to be true. We seem to have a consensus even in our committee that reforms are needed, and it looks like we have almost unanimity among the panelists. So it is a rare day for us in judiciary, but you talked about safeguards, you talked about transparency. If you could wave the magic wand, what would due process look like to you to safeguard the First Amendment rights, Fourth Amendment rights?
Right. I would make them broader than the First Amendment. I'd make them a constitutional right where you would give the court the obligation to look at what the government presented, and it had to be very specific, and there had to be a compelling reason before anything could be done in secret. And the minute that showing was not made, a series of other protections come in whereby counsel for the press can come in. There's no secrecy order, there's notice, there's no judges. But I think that it's very important that we have clear, articulated standards of what due process means in this case. So for example, I think cloud information should be treated the same as file cabinet information. There's no reason that those have to be separate. I would put that into the legislation. So I think it's a series of waterfall things that would follow one from another that would make it a very compelling and problematic for the government on about 95% of the cases that they're now proceeding in secret with.
Well, thank you. And Mr. Burt, you talked about judicial review, and you also talked about limiting the gag orders to 90 days and an extension requiring, a high standard for in any kind of extension. What exactly do you have in mind? Is this, and do you feel like the scrutiny for the extension needs to be the same or even higher than the original gag order application?
Well, I think it's the same standard that needs to be applied. It's really a strict scrutiny standard because you're trying to confine the First Amendment rights of the cloud provider to inform their customer about what's happening. And so you can say we've satisfied that for a 90-day period because we have one of these very rare special circumstances where that kind of secrecy is required in the national interest. And if a court is convinced of that and then puts the gag order in place for 90 days, that should be as long as it goes, unless government can come back and establish to the same degree, with the same degree of strict scrutiny analysis. So you have to come forward with compelling evidence and you have to show that there's no other alternative that can satisfy the government's legitimate interest. And so you'd have to reestablish that that is necessary for an extension of that 90 days. There should definitely not be any lower standard just because you got a 90-day gag order. If anything, as you're suggesting, perhaps at least the court should be considering, really, why do we need another 90 days?
Gentlemen, gentlelady's time has expired. Ms. Dean.
Thank you, Mr. Chairman, and I thank all of our talented witnesses for your expertise and advice to us. Ms. Oberlander, I'd like to compare and contrast some of the things we talked about earlier, which has to do with state standards as contrasted with federal standards. And obviously, we know where we stand on the federal standards. I come from Pennsylvania, like my friend and colleague, Representative Scanlon. Our SHIELD law is among the nation's strongest. In fact, our state courts have read our state legislation to protect as an absolute privilege any information which could expose the source's identity. Do you believe our state law or other state SHIELD laws that are much more effective could be used as a template for us here as we craft federal policy?
Well, I do, and Pennsylvania does have a good SHIELD law, and New York, where I live, has a very, very strong, also an absolute privilege for confidential sources and a qualified privilege for non-confidential material. And I absolutely think that those both could be models for a federal SHIELD law. I do think that because you have such a great experiment across all of the different states, that one of the places where the state statutes haven't kept up is on the definition of journalist. So it really does depend on which state you're looking at. A lot of them are, some of them at least, are tied to the fact that you have to get the protections of the statute, you have to work for a newspaper, a magazine, a digital radio. They don't necessarily permit without some challenge, like if you're an independent journalist now who is running a subscription newsletter or somebody, I work with a lot of journalists who are professional journalists, but they're not making any money. And so the definition of how you, within that is something that you'd have to look at. I wouldn't necessarily say that the state statutes are models on that. However, in terms of setting aside an absolute privilege for confidential sources and a qualified privilege, they are.
That's helpful. I'm thinking of my own constituents, journalists in the 4th Congressional District, and I have many. They feel, and if maybe you could detail the vulnerability, while they enjoy the protection of a state statute, depending upon geography, politics, and other factors, they are left vulnerable. Can you detail some of that tension?
Yes, and I'm going to use the example of New York again because that's where I've practiced, but if you are a journalist, you've done a terrific investigative story, let's talk, maybe it's malfeasance in New York City government, move it outside of federal, but there is, or it's a regular, it doesn't have anything to do with government, or it's a private malfeasance kind of investigative story, U.S. sources. If you get a subpoena from the New York State Supreme Court at 60 Center Street, and they want your confidential source information, who's your source, you can go in, you can waive the SHIELD law, and you don't have to provide your source information. It's an absolute privilege. Across the street in the federal courthouse, there is a different standard. It is a qualified privilege to the degree it exists, and you have to go, and there is something, and you do have to go and you show that, or the government or whoever is looking for the information would have to show that it's highly relevant to whatever their lawsuit, that they've tried to get it from other places, they haven't, and that the balance of equities generally weighs in favor of disclosure. But as a journalist, you may have to disclose your source. And so when you're talking, when you're reporting it, when you're dealing with your sources, you can't say to them with any real certainty, I am not going to have to give up your identity. And that creates an enormous havoc.
Incredibly dangerous. Thank you for that clear description. Ms. Burton, it's been more than 40 years since Congress passed the Privacy Protection Act. Now we see government can go directly to third-party providers to compel work product, as opposed to going to the journalists who were protected under the Act. The PPA is clearly insufficient. Knowing the actions of DOJ that have been discussed today, how should Congress specifically continue, and I know you've offered some, but continue to strengthen protections offered by PPA?
Thank you for the question. Of course, the guidelines first came because the Department of Justice was end running constitutional rights. And then when that barrier was not high enough, they went to warrants. Warrants were easy to get stamped in a court. And then Congress passed the PPA. Now we come to communication providers. I think that the legislation that's being considered here, the simpleness of it without a lot of other pieces, but just the simpleness of it to put procedures in place is what's going to be relevant, not just today, but whatever other forums and venues and technology comes in the future. I think it's about process, not about anything else. And so that's why I would urge us to get this bill passed into law quickly.
Gentlelady's time has expired. Mr. Stanton.
Thank you very much, Mr. Chairman. I want to say thank you to our witnesses for spending your day with us and assisting this committee in its important work. Back in early June, I, like all Americans, was shocked to find out the Department of Justice had secretly tried to obtain email records of multiple reporters in newsrooms like the New York Times, Washington Post, and CNN. It is frustrating to me. In fact, it's infuriating, to be frank, that the Department of Justice, under presidents of both parties, has led to hunting expeditions into the file cabinets of news reporters. Journalists and reporters serve a vital function in our democracy, working relentlessly to keep our public informed. Their work is tough, thankless, yet day in and day out, they do their work. They investigate leads, they find out facts, and they tell the stories that need to be told. It is freedom of the press that allows the American people to learn of the actions of their government, both good and bad, to learn of actions like the DOJ secretly surveilling reporters and our colleagues here in the halls of Congress. It is freedom of the press that allows the American people to stay informed, stay safe, to form their own opinions, and to be better citizens. So now more than ever, we do need to safeguard the protections of the First Amendment, and this Congress must do more to ensure reporters can do their jobs. Congress has in the past considered a press shield law. One issue when drafting such a law is the question that we discussed a little bit here today of who should qualify as a journalist and what activities deserve added protection. We can all point to responsible news organizations and journalists who are longstanding institutions of the press, but what about those others who may not fit the traditional mold? What about online blog or even someone like Darnella Frazier, the courageous young lady that filmed the murder of George Floyd and won a Pulitzer Prize special citation because of her courageous acts? Where do you draw the line about who would be covered by such a press shield? And open up to any of the witnesses to answer that question. I know, Mr. Turley, you put that some of that in your prepared testimony.
Yes, I did. And my objection to the current legislation is that it follows a rather dated definition of journalism. It specifies that this has to be part of your livelihood. It also notes that you should have a supervisor or editor that is overseeing your work. The fact is the media has changed dramatically, and today many bloggers perform many of the same functions as reporters. Many reporters are looking more like bloggers. You know, they're engaged in the internet and social media to a degree that they didn't. So you have this sort of merging. But you also have what are sometimes called net newsers. You know, today polls show that people now mix as sources of their media internet and traditional sources. In fact, more people get their news from social media today than newspapers. So we have to, as we talk about technology changing, we also have to update our view of what a journalist is. And this is not an easy task. I'm not pretending that this doesn't have problems. You can't make everyone a journalist, because if that's the case, then journalism means nothing. You have to have some way of distinguishing between what people do. What I've argued is it should be a focus on what their function is, their writing, as opposed to how much they're getting paid for it. So Ted Koppel tomorrow could resign from the network and be writing the same columns he did today. Would that mean he's not a journalist? Under this law, he would not be a journalist because he wouldn't be making any money at it. That's obviously something that we don't want to have an inherent flaw in a shield law.
I wanted to ask a question, Mr. Burt. You raised in your opening testimony the issue of blanket requests. This, I guess, is a relatively new phenomenon and obviously very frustrating for you and Microsoft, and maybe some of the other witnesses have experienced it as well. Can you explain a little more detail talk to us about that blanket request, what it is, and how we might be able to help you in Congress to fix those blanket requests for information?
Yes, so a blanket request like the one we received yesterday, and I think there was another one actually that came in, I was informed that came in today, is a secrecy gag order that prevents us from notifying customers, not just as to a particular subpoena or a particular warrant, but to all subpoenas, warrants, and orders issued in the course of a particular case or investigation. And what that really highlights is the lack of adequate standard to get a secrecy order in the first place, because that standard has to be particular. The government should have to show that for any specific request for data, that they can meet the standard, the strict scrutiny standard necessary to impose a gag order. But to say that you can do that for every request, in even the most routine requests for information and data throughout an entire investigation, just shows how this process is being abused.
Time is
Thank you so much. I yield back.
The gentleman yields back. Ms. McBath.
Thank you, Mr. Chairman, and thank each and every one of you for being here this afternoon. This is a pretty heavy discussion. And as Americans, we the people give our government a great deal of power in order to protect our national security. And these include the authority to collect some very sensitive information and to keep it secret. And we have laws, including criminal penalties, to make sure that secret stays secret when lives are definitely on the line. What I'm describing is how it's all supposed to work. Government actors are given significant power and tools that they're supposed to use to keep us safe. They're given the weighty responsibility of keeping information so secret so nothing gets out that could actually put lives at risk. But inevitably, there will be times when classified information is leaked to the press. We all know that. And in these moments, it can be hard to tell a brave whistleblower from an unpatriotic criminal. And it's often only in the writing of history that we actually will be able to say whether or not a leak was in the public interest or a serious threat to our national security. And so we have a complex set of tools and laws, and ultimately courts are tasked with getting this careful balance just right. The right of pursuing justice, protecting our national security, and also protecting the free press that is foundational to our democracy. So the question before us is whether that system is really working right now, or is it in need of repair? So one element of this system is the shield laws, state laws that allow reporters and editors and others to protect their sources. At least 40 states in the District of Columbia have some form of shield law on the books, including the state that I represent, which is Georgia. And I'm going to direct these questions to either Ms. Burton or Ms. Oberlander. Both of you, please feel free to jump in. Do these state laws vary in their approach to providing reporters protection from compelled disclosure? And also, to the extent that they do vary, has the state-by-state approach adequately protected our journalists that have been engaged in First Amendment activities?
Well, they do vary, as I previously mentioned. Some states have a qualified privilege for everything, where you have to go through some sort of balancing test before you can get it. Some states have a absolute privilege for, most places don't have an absolute privilege for everything, including, but for confidential sources, they might protect that absolutely. And there are variations, but they do all provide some level, well, most of them provide some level of protection. The federal circuits as well have different standards, and again, so you can completely depend on what circuit you're in as to what is the standard you have to prove. So all of them, the fact that there are these varying standards creates great uncertainty on the part of the journalists and of the people who want to provide them information. To your point about national security, though, and to the degree that there is a investigation into some type of leak or some other type of national security search, it would probably be under the federal, it would probably come out of a federal court, if not always, and then you would be faced with the question of which circuit you're in, and again, those standards do vary.
Okay, thank you. And Ms. Burton, did you want to respond?
Yeah, I wanted to respond to your first comment, which I think is very important regarding the balancing of national security interests, because we haven't really spoken about that. The Pentagon Papers case, again, 50 years today, makes notice of that, where you had a judge who was told that national security would result in the killing of many troops. And he took a very strong look at all of the information and then determined that, well, he couldn't be sure, that he had to balance against other rights, which in this instance were the press rights. And so that balancing, and courts that really look at these things carefully, whether it's in the Shield Law or national security, that's kind of the best you can get. There's lots of facts, there's a patchwork of statutes. We have to rely on the judiciary to do their job properly, and we have to require it of them. So I would say, on the state Shield laws, we could use a federal privilege on that. And I think that's the way in which you would begin to smooth it. But every state is different, and it's very much a patchwork at this point.
But thank you so much. And I'm about out of time, but I want to thank both of you for really giving us good detailed answers for these questions. And I yield back the balance of my time.
Gentlelady yields back. Ms. Escobar.
Thank you, Mr. Chairman, and many thanks to our panelists for being here today and for helping educate the committee and the public about what's at stake. And I think as we continue to read more information, I hope no more information emerges that there were more members of Congress, more members of the public, more members of the media whose privacy was violated. But as we may possibly hear more of that, I think it's critically important that the public sees that we take action and that we're responsive to their right to privacy, and that we are a country that honors freedom of speech, and that honors in many ways the press. And so, Ms. Oberlander, I'm going to have a couple questions for you, but I have to respond as the only member on this committee from the border and who represents a border community. I have to respond to one of my colleagues who has chosen not to govern on this important issue today and has instead chosen to participate in the Donald Trump, Greg Abbott circus that is happening in my state in South Texas. For the record, and just so that my colleagues know, for the record, apprehensions, or encounters rather, of migrants are actually down this year when compared to 2019. May 2021 versus May 2019, numbers of encounters are actually down. And I think that what we're going to see on the floor today and tomorrow probably will be an absence of many of our Republican colleagues who've chosen to abandon their job here in Washington, D.C. In an effort to participate in a political stunt. Back to the topic at hand, and actually, Ms. Oberlander, in some ways, this conversation about the border, for me, speaks to the importance of protecting the Fourth Estate. During the last 4 years, during the Trump years, much of what we learned about what was happening in the immigration space in terms of family separation, in terms of some of the cruelest, most abhorrent anti-immigrant public policy of our generation, we learned through the media. I served in Congress, was sworn in 2019, and much of the information that I gained even as a member of Congress, came from the media and came from courageous journalists who had cultivated sources, who were shocked by what was going on around them and who were willing to shine a bright light on policy that America deserved to know. And from my perspective, you know, I've been vocal about the Biden administration continuing to empower you know, the government in the same way, although I do want to recognize that the president has made some really important statements, but our DOJ is in some ways, you know, still engaging in the same way. Because you work with journalists and publications, can you tell the public what we risk if we continue to go down this road, their access to information, what you've seen and what lies ahead?
Thank you, Congresswoman. Yes, I think that if there are limitations placed on journalists, or that there is a fear that their confidential sources and their work product is going to be accessed inappropriately outside the rule of law, then you will see a real diminution in the flow of information. You really will. People will not agree to be, they will not come forward as sources of information. For example, around the border, you had sources within the government who were saying, these are the policies, this is what I'm seeing, but you also had sources, you also had the individuals who were affected by these policies, who really had the risk of retaliation, of being deported, and yet they were willing to come forward and say, listen, I am being placed here, I am not able to make a living wage, my children have been separated, and many of them were afraid of being identified and being deported. And so what happens then is, if they don't come forward, the entire public loses that information. We all miss the things that we would like to know to make our decisions, to decide who to elect, how to govern it, and it is a real diminution of the information available to the public.
It absolutely is, and that's why we have to take action, and I'm glad to see that there's bipartisan support for that, and look forward to working on the recommendations from this panel. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Ms. Jones. I'm sorry, Ms. Ross.
Thank you, Mr. Chairman, and thank you to the witnesses for your insights and for your patience. I'm second to last, so if you were wondering when you were going to have lunch, it's coming soon. As a state legislator, I worked to promote transparency and responsible governance in my state of North Carolina. And as a civil rights attorney, I've worked on both Fourth Amendment and First Amendment issues, and done a lot of work with the Press Association and to prevent state agencies and law enforcement from conducting unlawful searches. So this is a very, very interesting topic for me. Your testimonies highlight the abuse of prosecutorial discretion and do pose important questions about how we can act to fulfill our duty to preserve democracy and a robust free press. Unchecked prosecutorial power poses concerns for all Americans, regardless of their political perspective. And it's important that we usher in procedural and normative shifts that will emphasize responsibility with regard to prosecutorial discretion and secrecy orders on the part of law enforcement. Freedom of the press and government accountability are the bedrocks of our democracy. This committee has the responsibility to address and mitigate the potential for prosecutorial abuse and its actual overreach. But my first question is about business, Mr. Burt. And it seems like business has been unduly burdened by doing the government's work. And so I'd like to ask you what the incentives for service providers like Microsoft are to challenge legal demands issued by law enforcement agencies when they're legally deficient. You are getting a lot of these requests, and why are you resisting it as much as you are?
Well, my title actually is Corporate Vice President for Customer Security and Trust, and I mention that because a lot of the work that I do with my organization is designed specifically to try to ensure that our customers can trust us with their data and their information and with their transformation to a new digital world. And so it's very important to Microsoft as a company that our customers know that in these instances where we are subject to gag orders and we can't even tell them that their data is being demanded by government, that we will ensure that we only respond when those requests are truly valid and legal, and that even then we will challenge those whenever we have a sufficient basis to challenge those requests. We will challenge them if we can, and to try to limit the scope of these secrecy orders. And what we've learned is that litigation just isn't a sufficient tool. The volume's too high, the abuse is too great, and we really need legislative reform.
And can you just remind the committee about the business burden here? How many people hours, how much money does it cost you every year to deal with many of these illegitimate requests?
I don't actually have those numbers. We could provide those later to specifically address that. But we have a very large team that responds to lawful access requests. Globally, it's more than 60,000 a year. As we mentioned in our testimony, there's 7 to 10 of these secrecy gag orders that we get every day, and we have to review those for their sufficiency. We've litigated, I think, 8 or 9 cases, and each one of those litigations is expensive, and we've made progress through that litigation, but it is a burden to have to manage this, all because government isn't doing its job in an appropriate way.
Thank you. I look forward to getting that follow-up information. This next question is a follow-up on the definition of who the press is if we pursue the SHIELD laws. And Ms. Oberlander and Ms. Burton, we've heard from Mr. Turley about this, but do you have anything to add? Because I fear that that might be a place where it gets a little thorny for the committee.
I agree with Mr. Turley, and I believe that you should look not at who somebody works for, but at what activities they are engaged in. And are they regularly producing or writing or photographing or editing or involved with those people in putting news out of local, national, state, international importance to the public? Could be a small public, could be a large public, and I would look at that. And then around the edges, there will, whatever definition you come up with, there will be questions, and I think that then there have always been questions, and I think that that will be something that a court will have to look at the statute and say, well, does this person fall under it or do they not? So I would hope that the definition of journalist doesn't tie us up from not getting a SHIELD law.
Time of the gentlelady has expired. Mr. Jones.
Well, thank you, Mr. Chairman, for convening the full Judiciary Committee today to examine what we can do to prevent abuses like the Trump administration's secret seizures of data from the accounts of Intelligence Committee Chairman Schiff, Representative Swalwell, and numerous journalists. Let me be clear about something. The department must act faster to investigate, expose, and end these abuses. It is long past time for this Department of Justice to right the wrongs of the last one. I worked for the Justice Department early on in the Obama administration, and I understand that the integrity of the department is important. That is exactly why this Justice Department's reluctance to make a clean break from its predecessor's misdeeds is so misplaced. The way to restore the department's integrity is to repudiate the notion that the DOJ was Donald Trump's personal attorney, not to continue to provide him and his policies pro bono defense. The Trump administration may not have been the only administration in our nation's history to engage in these abuses. In fact, that is well established, but it must be the last. And so I look forward to working with everyone on a bipartisan basis for bipartisan legislative solutions to the challenges that we face. I want to focus in on something that a number of witnesses mentioned earlier. From what has been reported over the last few weeks, secrecy orders in particular have prevented the counsels of the targeted media companies from sharing information with their clients. And clearly these orders strain the rules of professional responsibility and attorney-client privilege. Ms. Oberlander, you touched on this earlier in your exchange with Ms. Scanlon, but I'd like to give you an opportunity to elaborate. Is there anything you'd like to add about this problem?
Well, I mean, I do want to say that letting somebody at the media organization know about the attempt to get their material is better than not letting anybody know about it. So the answer is not to not tell them. But it really does create a very, very difficult place for the attorney. I mean, it creates problems with their relationship with their client. It corporately, if it's a corporate issue, I mean, it creates issues with when you can't tell the CEO or the boss or the chief editor. I mean, it's really, it's just untenable, frankly, and it's not a solution to the secrecy orders to tell just one lawyer and gag them from telling anybody else. It also is, frankly, a prior restraint and creates and really should be looked at, like my colleagues have said, under the strictest scrutiny. I mean, if you can't stop the New York Times from publishing the Pentagon Papers, you should have the same standard before you limit their lawyer from telling the other journalists about the request.
Ms. Burton, what is your perspective on how these secrecy orders directed at the attorneys who represent journalists and media organizations can threaten or compromise the attorney-client relationship?
Yeah, thank you. Thank you for the question. I think that a statute that you are all getting closer to drafting here would create a separate cause of action to immediately go into a court to vacate that proposed order before the attorney is gagged. I have to say that I'm not sure I agree with Ms. Oberlander that it's better that someone in the organization knows. I think it is so corrosive when that occurs. So I would statutorily have a separate cause of action that would give the attorney and the business side of that operation the opportunity to challenge it.
Thanks so much. I just want to string together a few basic but vital concepts from the course of this hearing. Ms. Oberlander, there is no exception to the First Amendment for leak organizations, right?
No.
And nothing in the Constitution exempts leak investigations from the Fourth Amendment's protections against unreasonable searches and seizures, correct?
That's what I believe, yeah.
That's what I learned as well. Finally, nothing in the Constitution exempts leak investigations from the Fifth Amendment's guarantee of due process, correct?
That's right.
So as far as our constitutional rights are concerned, a leak investigation is like any other. Yet from what we have heard today, what passes for due process in these matters is anything but. And I just want to ask a series of questions on notice. Mr. Burt, I just want to review the notice process with you. When a subpoena is issued for someone's data to a third-party email or cloud provider like Microsoft and a secrecy order is imposed, the person whose data is seized is not notified in any way about the subpoena, correct?
That's correct.
And that secrecy order might extend indefinitely, correct?
Unfortunately, that's true.
How about when a secrecy order with a limited span does expire? Even then, at the expiration date, the law doesn't guarantee any notice to the person whose data the government has seized, correct?
It's correct. There's no requirement that government notify. We always do once the secrecy order is expired.
Even when there is no conceivable risk at that point that notifying the recipient could interfere with an open investigation or delay a trial.
That's right. There's no
Gentleman's time has
practice.
expired. The witness may answer the question.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Ms. Bush. Said Ms. Bush.
St. Louis, and I thank you, Chairman Nadler, for convening this hearing. The secrecy surrounding the issuance of the electronic surveillance and accompanying gag orders is deeply concerning. And in many ways, every actor is implicated, from the Department of Justice, which in this case has abdicated its role to uphold constitutional protections, to the private companies that followed the department's orders without any transparency, to the legislators who have thrown their hands up and allowed the DOJ to transgress without any accountability and transparency. While it is shocking to hear that the DOJ was engaging in such surveillance practices against government officials, their staffers, and their families, it is not an anomaly. As a protester and activist, I know firsthand how invasive law enforcement surveillance can be. It's for this reason that I have been vocal in my opposition to DOJ's blanket ability to surveil all Americans, especially Black and brown protesters who have been sounding the alarm on this issue. The department's ability to surveil Americans exercising their First Amendment right to protest has built the infrastructure that has now allowed the department to surveil members of this body. Companies like Apple and others are left are then left to hand over the records at their disposal, betraying the trust of the people who use their products. In this instance, Apple complied with the DOJ, demonstrating the thorny position of tech companies, balancing their customers' private online activity with legitimate requests from this country's chief law enforcement agency. Mr. Burt, it has been reported that some data hosts or providers have challenged the government's electronic surveillance orders and the gag orders. However, the company's ability to challenge the orders is limited and it is not assured. Mr. Burt, how does the abuse of secrecy orders affect investigations against Black and Brown communities?
Well, I think as you point out, you always have to be aware of the fact that government as a majority institution can sometimes disproportionately affect those in minority positions or who have less representation. And therefore, our Constitution and the constitutional rights on which our country is founded are designed to protect those minority interests and those minority rights, especially. And that's why when you have a law enforcement agency that's able to act secretly without creating the adequate record to be able to challenge and review those secrecy orders and understand the basis for them and to ensure that they're only issued when absolutely essential in the national interest, there is almost certainly going to be disproportionate impact of that secrecy.
Thank you. Can you tell me, how do you decide which orders to challenge?
Unfortunately, in most cases, we don't know enough because we are provided so little information. We don't know enough to even know when we have an opportunity to challenge. We challenge those that on their face are inadequate or clearly not legal. And in most cases, we find prosecutors then agree and withdraw that. And that's a big percentage that we challenge. We also challenge those that for other reasons we think we can negotiate a different approach by the law enforcement agency. But then we have to look at those relatively rare instances when we know enough or we can discern enough to know that we have a factual basis for litigating the scope of a secrecy order. And that, unfortunately, is too rare. And that's another reason why deferring this to the private sector, to the cloud providers, is not a workable solution. It's why we need to have a legislative solution that creates a greater burden on law enforcement and imposes on the judiciary the obligation to ensure that appropriate standards are met and a record of that is maintained.
Okay. So also considering the sheer volume of orders a provider like Microsoft can receive, how burdensome is it to require providers to determine if and when each order merits a challenge? Tell us about that.
Well, I was asked that question earlier, and I don't have specific data that I can provide about the nature of that burden. We take it very seriously. We have a very large team that's devoted to this effort and that is constantly looking at how we can best protect our customers' rights and interests. And so it's a significant investment by Microsoft in doing this work. And I think the point for the committee, though, is not about the burden on Microsoft. No one is going to be too sympathetic to the fact that my company has to spend money on this problem. The problem is you should not be deferring to the private sector that responsibility, because it could vary from company to company how seriously they take this. And we have only limited visibility and limited legal rights to challenge these secrecy orders. We explore those rights as much as we can. You can't count on every provider doing that to the same degree or to the same extent. And that's not where enforceability of these important rights should rest.
The gentlelady's time has expired. This concludes today's hearing. Thank you to our distinguished witnesses for participating. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.